So even I work with 2 orphanages. Every orphan is also given an Aadhaar card. So it is our mandate. I would say it should be a mandate for all the hospital owners, particularly for gynecologists and those who deal with PCP and MTP, to record the Aadhaar card of the patient to each indoor paper and preferably to each outdoor paper, because that is the government issued photo identity. Second is, try a call. They will take the mobile number. Immediately when the person is standing in front of you telling the phone number, give a call, a missed call. Verify that it is belonging to him or her. Many times we feel that they are giving misleading telephone number, misleading PAN number. So don't believe in that. Give a call and see that it rings into that mobile. So try a call on the mobile at the same spot. Who is authorized to write on the clinical notes? Only the registered medical practitioners. So only the registered medical practitioners, registered medical nurses, and those who are authorized people. So this is very important. Must contain the medication dosage, etc. We'll see what is meant by a good documentation. Skills for documentation is cognitive. So you have to understand what you're writing. Somebody else has to understand what you're written. So that is what is meant by the cognitive. It should be technically sound, ethical, legal, not to bypass something, no shortcuts. And it should be freely available as interpersonal communication. Next slide. I'm trying. Okay. Okay, sorry. No, I was using. Yeah. So this is easier to remember how the medical record should be. It should be clean. Avoid overwriting. If you have to overwrite, scratch the previous word and sign over it. At least put your initials. So documentation should be clean if you're writing it. Clear what you want to express, what you want to write down, what you want to communicate to the other person. It should be clean and clear, no ambiguity in what you're writing. So for example, temperature normal, that's not correct. You should say what is temperature is 98.2, like that. Febrile, you should mention that temperature was checked and temperature is so and so. At least it should be corroborated by the nurse's notes. They should be correct and true. It is worthless saying that you should be making any bypasses or shortcuts. So they should be correct, not only correct, they should be true also. They should be comprehensive. So whatever information you want to note down, useful for the purpose of diagnosis or for whatever reason, should be to that extent only. Nothing more, nothing less. So it should not be something like a big essay. It should be precise, but it should not be so small that so many points are getting missed. So comprehensive, not over or under descriptive, chronological, which goes beyond emphasis, that they have to be in orderly sequence. One case paper I will just mention over here. This has come from, all of you know Shirdi, Sai Baba ka place. So there is a very big hospital run by the trust. In that hospital, hysterectomy was done. See, the notes at that time were date and time of admission and a name. No address, nothing was written. Posted for hysterectomy tomorrow, hemoglobin 6, 4 bottles of blood. And on the next page, it was hysterectomy done, uneventful. These were the notes. I'm telling you the names of the hospital. And then it went to a criminal case because the ureter was ligated and all that. So you can see what extremely difficult to defend such a case. So there should be complete, comprehensive, chronological, complete, objective writing should be there. Confidentiality should be maintained. It is the duty of the doctor and hospital to maintain the confidentiality. Custody of the doctor. Whose custody is the documents? It is the doctor or the hospital. You can give a copy to the patient. That is the rule by NMC, that you need to give a copy if the person has asked you in writing that give me the total case papers. You number them and give them a Xerox copy of that. You put a signature over there, complete set of papers handed over, take a signature. But you may need to give the original documents to 3 places. Number 1, to the courts, if they demand. Number 2, to the police investigating officer, if they have got a written order from the inspector. And thirdly, to the insurance company. So they will return you back, but you need to give the original ones. Copies to be, this is a little change. Previously, the Medical Council of India said 3 days, 72 hours. Now they have mentioned 5 days. So a little relief to the doctors, and use only accepted short forms. So that is all CCCC. How long to preserve the papers? This is always a question asked in the conferences. I am clearing it here with some evidence, documentary proof that what government is saying. Medical legal cases, store them forever. Forever means till the doctor dies. Because once a crime, always a crime. Sorry. Once a crime, always a crime. So the case can come up anytime, but preserve the documents for 30 years. I inquired in Sassoon Hospital where I got trained, and they have the documents from 118 years. They are not destroyed any paper so far. But that's a separate thing because they get so much of space and all that. But what we are required is at least for 30 years medical legal. Administrative papers, registers for 10 years, indoor papers for 5 years. I will give a caveat to this. Put at least 2 years more, because 5 years is what NMC says. 5 years is what most of the courts all across the world are saying, 5 to 6 years. But then the courts may take more than 2 years more to send you a notice or at least the reply. Indoor papers for 5 years, OPD papers for 3 years. Though there is no mention of NMC, but there are two directives I could find from government papers. Government of Maharashtra, I will show you one, that they have mentioned that OPD paper for 3 years, indoor paper for 3 years. PCPNDT, these specific laws are there. They mentioned 2 years. MTP papers for 5 years. Newborn, obstetric and gynec. This is a catch point. So newborns and obstetric papers where the babies deliver, that baby to become adult takes 18 years, plus add to that 3 years. So that person becomes 18 years, that is adult age, plus 3 years chance to put your case if at all you are putting everything digitally, have the copy preserved and hand it over to the. So I'm giving some more details about cyber documentation in the subsequent slide. Yeah.
When they put that share screening, then the this is not working. Yeah, when they put the Zoom share screening,
Okay, so these are the various laws applicable to the e-health documentation, e-health data. So maybe it's not in one concrete place. That's why I'm shooting this slide. So what important precautions or what laws are applicable while we have the electronic records? One is the Indian Penal Code, which is now changed to BNS, Bharatiya Nyaya Samhita, which I have not studied much, but practically the most of the laws and rules are the same. So it's the old wine in the new bottle. Information Technology Act of 2000, Information Technology Procedure and Sensitive Personal Data and Information Rules of 2011, Clinical Establishment Act of 2010 passed by the central government, not yet applicable to all the states because they have to adopt it. Ministry of Health and Welfare EHR standards, which are published in 2013. I will tell you what is the hitch over there. And National Digital Data Mission, which is launched in on 15th of August, that's Independence Day in 2020. See, the problem over there is the entire responsibility of maintaining the confidentiality and that no cyber leakage will occur is cast on the person creating the data. That means you and me. And as far as I know, there is no system in the world, including WhatsApp, there's Facebook. They have also been leaked. I mean, they can be attacked by viruses and hackers. So it is, we have resisted it to the best possible level, and that's why the bill is still pending. So total security, totally cast on the doctor. However, precautions and security agencies you apply is not possible, and that the uh, punishment for violating that, or if some cyber data gets leaked, is to the tune of 5 years imprisonment and 5 to 25 lakhs of fine. So how the doctor will take the responsibility? Uh, so what are the types of documents or records? Is one is patient related, registration OPD. I think this is very simple to understand. CCTV footage is very important these days. So any violence act, some topic will be there at the end, that how to prevent violence. So CCTV installations in your clinical establishment is very important, and preserve it for at least 14 days. Third is financial bills, receipts, etc., and the registers, and income tax and professional tax registers are there. Then separate system of keeping important licenses. There are 108 rules or laws applicable to the hospitals, and you have to see. For example, you are meant, so many of you are anesthetists over here. You have the boil apparatus or other apparatus. They are functioning normally. Has to be certified by your company every year, and preserve that the person has visited your place and he has inspected and checked and kept that particular record. Keep a separate record. I would prefer for this the scanned documents on your computer. Electronic digital records are preferable. That is what NMC also says, but there is this problem. Police information cases, they have to be preserved forever till you die, and record should be objective, etc., which I already mentioned. Next one, please. So what are the other medical important documents? Are indoor and outdoor patient certificates. Very important topic. I think somebody will be covering it, or we can have it in the question answer session. Discharge card is very, whatever goes in the hands of somebody else is important. Discharge card, all certificates. Transfer papers and referral notes. Very important documents. Be very careful. Keep a copy of that attached to your indoor or outdoor paper. Invest and put a date and time. Investigation papers are important, that, but you can keep a copy or give the copy to the patient. Consents and denials, equally important. Another D important apart from documents is denials. So if you tell some procedure or some surgery to be done and the patient is vehemently denying it, not ready for it, take a denial. That is probably more important than consent. Prescription that goes in somebody else's hand, it has to be in a particular format which NMC has given. Develop a habit of putting a date and time. So it's not just enough to put a date, put a time, It may be 2 minutes here and there, but if the time right now is 10 o'clock, put the date. Today is 14th of June 2024, 10 a.m. like that. Next one. So how the document should be short, history, clinical notes, etc. I think all of you know very well. Investigation should be written on your paper. Always put the date and time. Our report. What should be the discharge card saying? You should never say the treatment is complete. Our treatment is never complete till the person dies. So never say you need not come. Even if you and me know this is defensive medicine. Even if you and me know that appendix has been done and is not going to require anything more, give a date 3 months down the line. Put it down. And in case in between something happens, report on this particular number or come immediately for showing. So all these are important. Exact dose, how many days it has to be given, that needs to be mentioned. Next one. So this is if you're handwriting, I mean, all the prescription, then drugs should be in capital letters. Strength of medicine should be written. Correct dose should be given. How many days it has to be given. Preferably, it is better in at least OPD practice, not even in indoor practice, but ask the patient to show the medicines once they purchase it. You know that famous case of Harjot Singh Ahluwalia. Professor Jogarao must be knowing about this case very well. This is a case where it's a vicarious liability case. The prescription given was of chloramphenicol and the drug given was chloroquine. And that drug without seeing was inserted into the tubing IV and the child became instantly brain dead. So chloroquine, this is a very famous landmark judgment. So Harjot Singh Ahluwalia versus Spring Meadows Hospital in Delhi, a judgment in 1998. The child is still surviving, but in a case of complete status of coma. So that particular case, only because the drug was not checked, what has been written and what has been given. Preferably give the follow-up date. Print at the bottom to the on your letterhead. It should be instructions for the chemist to call if this drug is not available, any side effects, and not to reissue the drugs on the same prescription. Next one. A carbon copy of a discharge or transfer note or referral note should be attached to your indoor paper. Then write treatment summary and yours. There is one interesting case on this. Can I have 5 minutes more, sir? Total 5 minutes more. So what is this? Writing summary. So whatever is adequate for the next doctor and hospital to understand in what condition the patient has come to me and what condition I am shifting to you. And that was given by a hospital in Delhi. And these were okay notes. According to me, they are very okay notes. Enough. And it was also written that if further information required, please feel free to call us. In the next hospital, after about 1 or 2 days, the patient died. The case totally survived on the point that whole set of case papers was not sent. And Delhi Consumer Commission, that's why I say pray judge. The state commission said that why whole case paper was not given and 20 lakhs was the fine given. So, I mean, this is away from standard practice. I advise the doctor to fight in the national forum. That's another story. But you know, to fight in the appeals and to go through all that hurdle is not so simple thing for a doctor. Next one. It's good for advocates to say that. So this is what I always recommend, that you should have it at the tip of your fingers on the, you can take a picture of this slide, that you should have these 3 judgments. The first one is not a judgment, but I'm sure in Karnataka also, there is Karnataka Prevention of Violence Against Medical Establishments and Medical Personnel Act. That is better than Maharashtra Act because it has been recently amended. So have that copy on your laptop, on your mobile. Second is Jacob Matthews versus State of Punjab. This is a landmark judgment so that they cannot arrest you. And third is Martin D'Souza versus Mohammad Ishfaq. These 3 are landmark judgments to help the doctor. Next. And this is probably 1 or 2 last slides. Yeah, this is why I always end my talk, maybe it on any subject. I go on modifying it every now and then. This is the ABCD Veda mantra for prevention of medical legal litigations. Though I cannot assure you that it will never occur because it depends on the other person. A stands for attention and additional opinion. And I added to that, appreciate the previous doctor. Never criticize. So appreciate the previous doctor. Oh, that doctor has done wonderful, but let's try this way. That is what I mean by additional opinion and appreciating the previous. Attention means howsoever ridiculous the complaints may be of the patient, they are usually correct. They may not be able to express it well, but usually this is after 50 years of practice, I'm telling you that most of the times patients are right. What they are telling, don't easily label it as psychological. That's a big mistake. B stands for behavior and bills, because it is your ultimate behavior, how you behave with the patient will drag you into the court. It is not a point of negligence, but then it may drag into litigation. Bills in standard cold cases where the procedure is informed that this is a cold case and this is a planned case, you should be able to give a fair estimate if there is no comorbidity. If there is comorbidity of diabetes in particular, steroid treatment, HIV, cancer, or hypertension, you cannot give proper estimate. But otherwise, we should be able to give the estimate. C stands for communication, very important. Consent or denial. It also stands with CCTV. It stands for counseling. So consent should be after counseling. No doctor can be a good doctor without having compassion in his heart and mind. So that is all about C. D stands for documents, and these are indeed your only friends in case of medical legal crisis, but they can turn into foes if you don't maintain or preserve them well. E stands for expertise.
Hello.
Yeah. Finished. E stands for expertise, efficiency, and empathy. So efficiency, add to that equipment, that E is missing. Efficiency, expertise, empathy, and equipment. F and G stand for good faith. That is a defined thing in the criminal law. And I stands for identity. Identity is that Aadhaar card. Insurance, adequate insurance is required. That topic will be there. And J stands for jousting. That is criticizing the previous doctor. Never, never, never. Adverse media publicity as of today cannot be prevented effectively. With this, I conclude my talk. And this is a certificate program we are running on a regular basis with the help of Medical Legal Society. Dr. Kumar is also delivering lectures in that. And we will have many more lectures from this August audience, included in this. 7 such courses have been completed in a span of, every course is 13 weeks, every Saturday, so that you can just communicate to us and we'll send you all the details. Thank you very much for a patient listening. And I conclude my talk that none of you should be entangled in the medical legal issues. Even if you escape, the headache is enough. So that should not occur to a practicing doctor. He has enough to concentrate on his clinical acumen, his own medical studies, and he should be leading a comfortable, quiet life. Thank you very much.
Thank you. Thank you, Dr. Jayant, for your very informative talk on the very important topic, documents and documents, because prevention is better than the cure here also. And so many things will end up in the, if you don't keep the documents properly, it causes us a trouble later on, because some of the documents has to be kept for 30 years and 10 years and so on.
Yes.
So thank you very much for your
Dr.
beautiful
Ballari.
talk.
Thank you.
And any questions, please?
Myself, Dr. Shekhar Sajjana, General Surgeon from Gadag, former Karnataka State RTA Commissioner.
Yes, sir.
Very nice lecture from you, sir. And regarding the case sheet you said, so under RTI, anybody can seek any information from anybody all over India, except there are 3 exemptions under RTI. As you said, the medical records belongs to one particular person. Only his legal heir can seek the information. Information can be provided with the consent. Isn't it? Number 1. Number 2, other than a person, nobody can claim case certificate, case sheet of a patient. There are 3 sections in RTI. Section 8(1)(e). There is exemption. It is a relation between the doctor and the patient. This information cannot be furnished to the third person. That is section 8(1)(e). Then section 8(1)(j), that is a personal information of the particular patient. It cannot be furnished to third party. Section 11 of the RTI Act says there are 4. You have to serve notice to the concerned person under section 11(1). You have to, within 5 days, you have to wait for 10 days to seek his opinion. within 15 days, totally within 40 days, you can furnish the information provided if he gives the consent. Otherwise, no. He said, regarding the what about the spouse? There are so many litigations regarding the husband and wife. There is a dispute going on in the court of law. They are seeking some medical information from spouse. In that case, information cannot be provided even to the spouse. No. There is a apex court judgment in 2011, CBSE versus Aditya Bandopati. It clearly says third person information cannot be furnished to anybody unless he's cut. I think there is additional information for you. Thank you very much.
Thank you, sir. Thank you.
Sir, you meant legal spouse, isn't it?
Sir, if I mistake not, and if I'm not wrongly conceiving the section 2 of RTA, that mentions that it is applicable to the government institutes, government-run institutes or substantially government-aided institutes and not to the private sector.
This RTI, it is say section 2H says all government hospitals and also which take substantial funds from the government, they are covered under RTI. Private institution, they are not covered under RTI, 100%. And regarding these cases, even private persons cannot disclose the information to the legal aid without the consent of the person.
Right.
Isn't
Oh,
it?
yes.
Right.
So it was very nice, sir, by Dr. Jain. And
you, sir.
he mentioned in one of his slides that it should be clearly written. So that is one tough thing for us as doctors. But I remember Dr. Godkindi telling me very clearly, you write it not for you to read, but for others to read. So that's what a documentation should be. And electronic medical records have got its own fallbacks. I think we have come to the end of this talk. Thank you, Dr. Jain. Thanks. It was very wonderful.
Thank you so much, sir. And sir, we request you to please come forward to accept the token of our gratitude. And sincere apologies to you, sir. There were a lot of disturbances and yes, thank you, sir. You were very patient and kind. Thank you, sir. Now I request Dr. Suresh Badamat, sir, to please come forward for the next session.
Yeah.
Sir will be speaking on medical negligence. I request Dr. Guruprasad, sir, to introduce the guest.
Welcome, Dr. Suresh Pada. He'll be talking on medical negligence. Again, a very hot, sizzling topic. So he's done his MD, DNB and PG diploma in medical law and ethics. And he's done his PhD in law from NLSIU. He is presently a professor and head of the department of NIMANS Digital Academy, head of Forensic Psychiatry Services and in NIMANS. Okay, he is a visiting professor at National Law Schools in Ahmedabad and Aurangabad. He's got about 435 publications in Index Journal. That's too much of a publication. He is an influencer in the sense he's got his own YouTube channel and he's got 572 plus videos. That should be wonderful to watch. He is an chairman of the task force for mental health and well-being of medical students of the NMC. And he is a proud awardee of Professor Raghuram's Distinguished Young Teacher Award and C.V. Raman Young Scientist Award by Government of Karnataka. So with these few words and with his introduction, you know how academic Dr. Suresh is. Over to you, sir.
Thank you, sir. For the august audience, today I'll be discussing about medical negligence. So in this next 25 minutes, sir, I'll take 5 minutes more. I have timed it. I'll be talking about BOLAM test, BOLITO, and how the medical negligence is assessed. So first, you need to know the basics of medical negligence, that is BOLAM test. This BOLAM test occurred somewhere in 1952 in UK. This is again from a psychiatry patient who is having recurrent depression. Imagine 1954. In 1954, just think that you're in Gadag and a psychiatry patient comes to you for treatment of depression. So at that time, medicines were very less. But at that time, electroconvulsive therapy was introduced. So then they say, okay, you take electroconvulsive therapy, nothing but ECT. He agrees. First sitting of electroconvulsive therapy is given. After 2 days, second sitting. See, invariably why ECT is given is basically at that time, the thinking was if the person develops seizures, psychiatric symptoms will go. You need to induce seizure. The only way to induce was provide electrical stimulation or else camphor. That was the another method. So in the second sitting, he has a seizure. Unfortunately, acetabular fracture occurs because of the violent seizure. But his depression goes off. But he is very angry, telling that I came for depression and you people have given a acetabular fracture. He goes to the court. Now, for a moment, think you are the judge. In 1954, and you have to decide the case. At that time, there is no law with regard to medical negligence, no case specifically mentioning the yardstick for medical negligence. So the Judge McNair calls the experts. So the experts at that time got again divided. One group of experts said, sir, before we give electroconvulsive therapy, we give anesthesia and muscle relaxant. The other group said, imagine it is 1954-58. Sir, anesthesia at that time is dangerous. It was ether. Muscle relaxant also was not at that time properly refined. So imagine 50% of the experts said we will give ECT without anesthesia and muscle relaxant. Another 50% said we give. So now again, Judge McNair is in the limbo. What should I do? Should the psychiatrist to be punished or not to be punished? So the Judge McNair at that time in 1958 gave a landmark judgment. If the doctor follows one of the prevailing guidelines or the procedure, the doctor is not negligent. So this is a landmark judgment in the history of medical negligence, which came from psychiatry. And now this test, Bolam test, because the patient name Bolam test they have considered, and it is accepted even in our India. You take any of the land. So the Bolam test is applied in almost all medical negligence cases. It is in simple words. If the doctor is able to follow the reasonable practice, he is not negligent. The court does not want you to give a higher standard like AIIMS Delhi, or else the lowest standard like a quack. Reasonable practice. That is what the law wants. It is not expecting you have to become AIIMS doctor kind of thing or Niemann's doctor kind of thing. It is a reasonable degree of practice. That is how this can be considered, and it has been accepted in even Jacob Matthew versus of India. So how you can understand this? It's like if you are able to provide a reasonable care, it is not punishable offense. If the reasonable care is failed either by doing something you're not supposed to do or not doing something you're supposed to do, then it is called as medical negligence. What is the criticism of Bolam test? Of course, since whenever the negligence has to be assessed, you are calling your own fraternity. The lawyers are angry, telling that the doctors will never give opinion against doctors. That's the society believes. But we know our doctors are the biggest enemy for another doctor. They will give opinion at the drop of the hat. As a IMA member, I would like to tell we are all divided by specialty, not united by MBBS. Unfortunate this is. As you meet any doctor, kya specialty sir nimdu? And if you are just an MBBS, you don't exist in front of a specialist. We don't support our fraternity. And imagine, recently one case came from Mangalore who had treated a Parkinsonism case, 15 years, doing very well. But unfortunately, because of Syndopa, he developed movement disorder. Family is furious. They brought to him and, sir, look at this fellow. They have given Syndopa since 15 years. He's shaking and he's having psychosis. The doctor ruined the life. We had to immediately tell, show the prescription. So doctor has done a wonderful job. For 14 years, he did not add any symptoms of Parkinsonism. Even if I am the doctor, I would have done the same thing. But none of the doctors do this. We escalate the issue. Oh, he did this. That fellow is like that. I will give you certificate. Put a case against him. I know Shivkumar Kumbar. He will give you opinion. I know our Joga Rao sir. He will fight your case. We unnecessarily escalate the issue. We don't require enemies. They are sitting next to each, next to each, what is that? Next to you. Enemies are, okay, this is the criticism, but unfortunately, the doctors give opinion against the doctor easily. But at the same time, because of this, there is one more test came into picture, Bolitho test. We finished Bolam, reasonable degree of care. What is Bolitho test? Here again, a young boy, Patrick Bolitho, he is around 2-year-old. He is having a severe cough with breathlessness, admitted to ICU. And of course, in the night duty, he has severe breathlessness, starts coughing very violently, becomes cyanosis. The nurse will call the duty doctor. The duty doctor is in the casualty. Sir, the child is coming, coughing very badly. Patrick, why don't you come? By the time he comes, the child is recovered. Second episode also occurs. The doctor was about to come, the child recovered, nurse said, sir, recovered. Third episode, severe cough. Child develops a brain damage before the doctor came. The child develops severe brain damage, hypoxic, and it is now goes to the court. By the 30th day, the child dies also. This case goes to the court. Now the Bolam test is applied again. So one group of doctors said, if I had seen the case, I would have done the intubation and given oxygen. The other group of pediatric specialists said, no, sir, the child is already coughing. How can you do intubation? The child will die there only. So two practices are there. One is do intubation, give oxygen. Another one is don't do intubation, don't give oxygen. The child is already coughing. Nothing can be done. Maximum tracheostomy, but it is again taking the child from there to OT, it will take time. So these two practices are there. Now the issue came is whether the doctor is negligent or not. First time again, the court said, the doctor should have gone there first. And you don't have a medical expert in the ICU. The third time, the doctor did not visit. Forget about giving the opinion. That time, the Bolitho test was brought into picture. It said, the doctor fraternity can give any kind of opinion, but it has to be logically explainable to the court. Bolam test is there, fine. The doctors have given opinion, but you need to justify in the court of law. Yes, this is a logical opinion. I will come to this. Our doctors make a huge mistake when they give opinion. You can't say that according to me, I'm working here since 30 years. I am the best expert. The doctor is not negligent. No, you need to give logical explanation why the doctor is not negligent. That's what the Bolito test comes into picture. Luckily in India, only 2 cases, the Bolito test has been applied. Till now, it has not been considered. Bolam, Bolito done. Bolam is reasonable degree of practice. Bolito is the reasonable degree practice. When an opinion is given, it has to be logically explained in the court of law to convince the court. Just because doctor has given will not be accepted. Now let's talk about medical negligence. To assess medical negligence, there are 4 criteria. One is there should be a duty of care. The doctor has come and met Dr. Pavan Patil, and Dr. Pavan Patil has seen him and touched him. The duty of care exists. Next one is the breach in the duty of care. He is supposed to provide a care, and that care, there is a breach. The breach can be by doing something or not doing something. Act of commission or omission. Because of the breach of duty, there should be a damage. That damage should be very, very reasonably close to the event. It can't be remote. Imagine Dr. Pavan Patil has done the operation. Everything is fine. Today they discharged. The patient starts walking outside the hospital. Suddenly the vehicle comes and hits him. Hello. Hello. So if the person meets with an accident, if the lawyer says, if you go to the court, accident case, very minimal amount, maximum is 5 lakhs something, put a case on the doctor. Dr. Pavan Patil, before discharge, gave one medicine. Because he took that medicine, when he was crossing the road, he felt giddy and fell in front of the vehicle. Ask 11 crore now. So it's easy, but that medicine should have clear-cut side effects. So that is what is the remoteness comes into picture. It should not be easily relatable. That is what we call it as causation and should be easily established. So now, so medical negligence, Bolito, Bolam test, you need to have 4 criteria. Duty of care, breach in the duty. Because of the breach, there is a damage. The damage should be not remote. This is medical negligence. Now let's understand the medical negligence are 3 important types we would like to bring in. One is criminal, civil, and disciplinary. Criminal is police case. Civil is compensation either in the consumer court, disciplinary state medical council. Simple. But when you are an expert, when the police will ask you for an evidence or an expert opinion, your opinion should be very clear. Am I giving for a criminal case versus civil case or for a disciplinary? For a criminal case, the negligence should be very gross. I'll give an example. One of the case which occurred in Delhi, the doctor made a mistake, but there was no negligence. Medical record was not good, as our Dr. Jain said. The medical council expert had written, the doctor has been warned for the not keeping the record properly, but we exonerate him. The police constable said, see, there is a warning. FIR was made. Under no circumstances, stretch of imagination, even civil negligence cannot be made just because our expert wrote telling that the doctor has been warned for medical records. That kind of expert opinion should not be given. It will destroy the morale of the doctor. Not only the doctor, the society will see what kind of doctors we are having in the society. That's the way the society will look at us. So how So evidence required is the essential. For criminal case, it would be beyond reasonable doubt, 99%. For civil case, it is the probability. Which is more? In the Pavan Patil case, example I'm giving you, if the patient gives 49% and Dr. Pavan Patil is able to bring 51% evidence, Dr. Pavan Patil will win. It is not beyond reasonable doubt. Civil cases, who has more evidence? In criminal case, it has to be beyond reasonable doubt. So that you need to understand as an expert. Now let's take one of the important criminal case which occurred, Jacob Matthew versus Union of India. In 92, Jacob Matthew was a doctor, final second year surgery PG. He finished his OT at around 8 o'clock in the night in CMC Ludhiana. He's coming out of the surgery OT. In the emergency ward, there was a commotion going on. Nurses are running here and there. And one of the nurses will come, Dr. G, please come and see one of the patient in the special ward is disturbed. So the Jacob Matthew will ask, what is happening, Sister G? Then the sister will say, see, we have an elderly man around 85, 90. He has a cancer. It is a terminal cancer. His treating doctor said, please take him home. We can't do anything. But the family members were so powerful. They said, please keep him. We can't take care of him at home. And they were politically related and also bureaucratically related, his children. So because of the pressure, they have kept him in the hospital. So Jacob Matthew felt, okay, let me see the case, because he was nowhere connected to the case. Let me be very clear. He goes there. It is a special ward. He will examine the patient. Patient is gasping. He'll say, please get the oxygen first. So it was a special ward. From the ground floor, they brought the cylinder. They put the cylinder was empty. By the time they brought the another cylinder, patient died. He was terminally cancer patient, died. Since the family members were so powerful, they called the police. From 9 to morning 4 o'clock, Jacob Matthew and the colleague, who was another doctor, were kept there. Police were coming, threatening them. How can you kill a senior fellow? How can you put an empty cylinder on him? Lot of hangama occurred. The body was taken. Dr. Jacob felt, okay, fine, everything is done. So he goes back. He continues his MS surgery. After 30 days, he comes to know there has been a case filed against him. Now he is running for anticipatory bail. He gets the anticipatory bail. Case goes on. He is passed. He is now practicing in Kerala. Now he becomes very disturbed, writes to the Supreme Court. How can this happen? I was nowhere connected to the case. I went to help the patient. And I'm a PG at that time. I'm not even in charge. How can you? So please understand here one thing. Vicarious liability is only for civil cases. Criminal cases, the person who is there. Example I will give you. Our Dr. Hadamant Mali is here. He has a driver. Both are coming from Hubli to Gadag. A young boy comes in front of the vehicle. They hit the boy. If there is a civil case, compensation for the boy. They can't do anything with the driver, owner of the car. Anumant Mali, you pay this much amount. That is civil case, vicarious liability. Criminal case, rash and negligent driving will be against the driver, not against Hanumant Mali. You understood? Vicarious liability is only in civil cases, not in criminal case. So similarly here, they said, see, there is a criminal case. You are the person who were there at that time. You are the last attending doctor. You will be held responsible. But the Supreme Court took the case seriously, heard it, and again a landmark judgment was given in this case. Jacob Matthew versus Union of India. If Archana Sharma knew about this case, she would have not committed suicide in Rajasthan. So I urge all doctors to know about Jacob Matthew, at least read this case. What does this case talk about? It says, whenever there is a complaint is given regarding a rash and negligent act causing a death of a person, the police cannot make an FIR, but they have to go take the body into their custody, take all medical records, take the medical records subject to the expert opinion. Invariably, they go to IMA or they may go to State Medical Council or to the Government Medical College. They have to take an opinion telling that, yes, there is a prima facie case for negligence. Then only they can make an FIR. Again, FIR subject to, there should be postmortem report, all the reports are available, then they can make an FIR. Even if they make FIR, they cannot arrest the doctor unless the police believes this doctor is going to escape from this place, then only they can arrest. This is a landmark judgment. At least in Karnataka, we have educated the police and there are circulars, both in Tamil Nadu and Karnataka. IMA has fought for this. So please know about your rights as a doctor. Police cannot just arrest you in rash and negligent act causing a death of a patient. So if you, that was the earlier IPC 302, 304A, but again in BNS, there was a lot of political hangama. I will not go into that, but still in BNS, it continues to exist. 2 years imprisonment is there with the fine. Previously, it was 2 years imprisonment or fine or both. Now, imprisonment with fine. So that is Bharatiya Nyaya Samhita. Coming to civil negligence. So criminal negligence, it should be very gross negligence. What is this gross negligence? No doctor will do that. That is gross negligence in simple, concrete words. In civil negligence, it is the reasonable degree of doctor. Okay. In civil negligence, I will give you last couple of slides, sir. Please understand, in civil negligence, whenever there is an expert opinion is asked. Example, I will give you. One of the OBG gynecologist, madam, is here from Pune. A death in a rural PHC has occurred during labor. And he is a MBBS doctor. And now the medical record has come to her, asking for opinion. Now she is sitting in a Pune Sassoon hospital. She should not think if it has come to Pune Sassoon hospital, she should think, she should shift her mind now. If I am sitting in that PHC on that day, that is 10 years back, in the night at 9 o'clock, the nurse has gone for a maternity leave. Anesthetist has gone for, is on long leave because he's been transferred. So she's alone. What she can do? That should be the attitude of the expert opinion when they give opinion. It is not that armchair in Sassoon hospital in a AC room sitting and telling, if I am seeing this case, I will do A, B, C, D, and this doctor did not do. That will be completely wrong. It is the circumstantial event has to be taken into consideration. My dear friends, even when the death penalty is given, the court, Supreme Court wants what is the circumstances when he committed crime. He has killed 3 people. Before they give death penalty, they have to take an opinion. What is the evidence? What is the circumstances? Here, we don't even think about that. At the drop of the hat, we will say this doctor is negligent. He is an MBBS doctor. He is not supposed to do either episiotomy or labor. He is not supposed to do it all. And we give opinion, yes, he has to be punished. And if it is a police case, you have to see whether it is a gross negligence. If it is at the similar time in PHC would have done the same or not, which has, okay, that is, I will not go to that. That is one of the landmark decision is there. Kusum Sharma versus Batra Hospital. That's the court has given. But now I will go through this one last case. This is Jashwinder Singh versus Neeraj Sood. This was given in 2024. Here is a young boy who has congenital ptosis. from birth he has. He goes to PJ Chandigarh. In PJ Chandigarh, there is a senior resident in ophthalmology department. He says, let me do this operation. He has done around 60 operations. Congenital ptosis, he operates the child for congenital ptosis. Unfortunately, what happens is it worsens. Now, can it be a criminal case? No stretch of imagination. It can't be gross negligence. But civil case was put against them. PJ Chandigarh with the doctor who was a senior resident telling that he was negligent and the ptosis worsened and even the eyesight also worsened. They asked for a compensation. State consumer said there is no medical negligence. The doctor did the procedure and the patient could not establish there was a negligence. But unfortunately, National Consumer Forum, our own doctor who was sitting there, felt that he has to be punished. And the National Consumer Forum gave a punishment, telling that this amount of money to be paid. It was challenged in the Supreme Court. Supreme Court categorically said that just because there is a adverse outcome of a case does not mean it is negligence. A. B. To establish medical negligence, the patient has to prove there was a negligence by an act of commission or omission. For that, again, what is that medical negligence? You need to provide reasonable skills, reasonable knowledge, and reasonable care. Has been breached. The patient has not done that. Remember SKC, reasonable skills, reasonable knowledge, reasonable care. Our doctors who click NEET exams, they have amazing knowledge, poor skill, bad care. Their knowledge is phenomenal. You ask better than ChatGPT, they will give you answer. You ask them to put an IV line, they don't know how to put an IV line. Or you ask them to talk to a patient, they don't know how to talk to the patient. They will talk like an MCQ. So this is a landmark judgment. Please go through this. Again, the court has said the patient has to prove that there was breach in the reasonable skills, reasonable knowledge was not applied, and reasonable care was not given. And this case, the doctor was allowed to walk away, both PJ Chandigarh and the senior resident. So just because you are a senior resident, Gadak Medical College will not be pulled into picture? No. Civil case can come. Criminal case will be the last doctor who is saying, even it can be an intern, can be pulled in the criminal case. So that is about the medical negligence. This is the case I told you, Kusum Sharma versus Batra Hospital. Please go and read. If I give you everything, you will not learn. Go and read about this case. If you type it in Google, you will get the whole thing. Thank you one and all for your patient listening.
It was really a wonderful
Thank you, sir.
talk. Yeah, that's what you told in the end. So we would request to give us a link where we can find all these landmark judgments so that we can go through it
Sir,
in the WhatsApp group or whatever it is.
Sir, my YouTube has all
Acha.
those videos.
Okay,
One.
yeah.
And recently in NMC, I am a medical legal expert there. We have written 4 books on this. And it is available. I shared with the IMI team.
Yeah.
That can be shared with everyone. There we have given all landmark judgment for all the cases which reached NMC.
So his YouTube channel is at Suresh Baramat. Okay, if you visit that, then you will get all the landmark judgments. Any questions from the
Previous
delegates?
speaker wants to ask, sir.
Sir, it was an excellent speech and very congratulations. for
Thank
the
you, sir.
same. What I feel is that what you said about the expert opinion is the real crux of the problem. Real crux of the problem. The expert committees which are sitting in the medical, and most of them, they have mentioned preferably government medical colleges. Or sorry, preferably government officer. That's where they are not giving directly, is it amounted to criminal negligence? Because jagging is happening. This would have been better.
That would have been
The
better.
consent doesn't seem to have been validated, like thing, and then the police go to the doctor's chamber saying that you are under arrest for 304A. So I think the time that expert committees need to attend such talks.
Yes.
And I would definitely call you once, because we will be holding such type of seminar, because that is real problem, that once police say that once your own people have said that there is some doubt of negligence, they would
They'll file the
be
FIR.
free to apply this 304A or 106 under BNS.
Sir, according, as you mentioned, we have trained Punjab, Haryana, we have trained Maharashtra Medical Council, we have trained Bhopal, that is Madhya Pradesh. Recently, 2 weeks back, we finished for Orissa Medical Council, Delhi Medical Council. We are in touch with them, how to give expert opinion, how to write a speaking opinion, and how the logical explanation should be given, and what are the documents they referred. And I request our experts not to quote foreign evidences. Please don't do that. The drug of choice in the foreign textbook is different, or the papers is different, guideline is different, Indian is different. In India, in epilepsy, still we use phenobarbital, which has been banned in US. Again, the law is applied is Indian law. So use Indian evidence, Indian textbooks. Don't use foreign textbooks or foreign guidelines. Please use Indian, because we are applying Indian law. The doctor is practicing in India. And if he is practicing in rural area, think 100 times writing something against him. This is my humble opinion, one. Another one is, don't criticize any doctor's prescription without knowing anything. Don't aggravate the situation. Patient is in pain and you say, who is this doctor who is nonsense? He has given this prescription. Don't aggravate the situation. Talk to the patient, say, come on, let's discuss. What is the problem? We'll try to solve it. I don't know anything what Dr. Hanumant Mali has done, but let's discuss. Come on, we will discuss. What is your pain? We will try to rectify it. Don't pour kerosene or petrol into the patient's pain already. This is done by all our doctors. Please don't do this. This is my humble request. The number of cases are increasing because another doctor would have done it, and our Karignur sir is also here. He knows most of the cases other doctor would have pumped the patient, telling that go to the court. Please don't do that. Even our Jogara will say, he feels for the patient. I know our doctors are not done wrong and the patients have been unnecessarily provoked. And the patient party is running. And the doctor is also running. That should not happen.
Yeah,
Can we have a legal cell in every IMA branch, so that whatever, like if something goes wrong in anyone's hospital, first they have to approach legal cell and their committee doctors, and along with the patient relatives, we can go and solve there itself. So
Karignur sir is sitting next to you, madam. He will give you what is the legal cell are available. He is also very active. It is there, ma'am.
but can we make a rule that first it has to go to local IMA branch and
Madam,
then go to court or
thank you, madam.
Yes.
National Law School, I'm speaking to Jogarao. Jogarao sir says, don't write law for everything. Tomorrow you will say, when you enter the hospital, put right leg. And if you put left leg, they will say you put wrong leg, it is a medical negligence. Don't write law for everything. Don't ask for law. This is a professional area. It is left to us. Everything is written in law. Then if you make one mistake, you will be held responsible. I used to believe that when I finished my PhD in law, then I realized we should not write law for everything. Tomorrow you may ask, unit 1, unit 2, unit 3, how should they function if you write a law? Gone. You will not be able to work at all. I'll give one of the best example which occurred in Apex Institute. This happened around 8 or 10 years back, before the art law came. One unit treating the fertilization, they have taken oocytes. In that time when they got around 16 oocytes. They are frozen and they kept it. And one of the oocyte, the lady got the fertilization, healthy baby, she went off. This frozen oocyte was there, another 3-4 ladies from another unit. They were unable to do it and they are all poor patients. So Another unit head said, see, I know there are 18 oocytes. Why can't you go and ask the permission of the unit head one and take it? They told the SR. SR called the SR of the unit one. See, look at the communication gap. He said, I will tell madam, you take it. It did not happen. And the unit 2 head went ahead and did it. And later unit 1 came to know without my knowledge how it happened. And tomorrow this unit 1 doctor proxy complaint was given in the Delhi Medical Council. It became a and the whole team was a simple issue. No money was involved, and they are all the.
Suresh,
Thank
I
you,
think
sir.
further discussions during tea time.
Thank you, sir. Now I request our chairperson, Suresh Padman, sir. Thank you, sir. Wonderful session on medical negligence. Now with Dr. Shukumar Kumar, sir.
He will light up the stage.
I am pleased to introduce our friend Professor Dr. Sivkumar F. Kumbar. He is by advantage very quite a big one. And I would like to cut short because of the paucity of the time. Professor Dr. Sivkumar F. Kumbar is an anesthetist and lawyer. He has got so many degrees also. MBBS, DA, FPAI, Bombay, LLB special. He stood third to the university in the LLB also. And LLM, PGD, MLS, PGD, MLE, MBA, CCPEC, CDM, UNESCO, Bioethics, MA Journalism, FIAMS, and so on. So many things are there still. IAS MP in sexual medicine. So many degrees are there. He has not mentioned. He has traveled almost all over India for the medical legal lectures. He was given lectures all over India. And he is MBBS from Memorial Medical College, Gulbarga in the year 1982. He passed a DA from the Karnataka Institute of Medical Science, Hubli, 1992. He is a LLB special, Karnataka University, Dharwad in the year 2006. And MBA Hospital Administration and MA Journalism. Then postgraduate in PGD MLS, Medical Legal Systems, Symbiosis at Pune also. He is a postgraduate Medical Law and Ethics, PGD MLE from Bangalore. And IAPC, it is a fellowship, I think, in the pain and palliative care from the Kidwai Institute of Bangalore. And Certificate of Dispute Management, CDM, from Cochin. And a fellowship FIAMS also in the medical science. He is chairman IMAMS Karnataka last year. He has served in almost all capacities at the IMA branch as well as the state level also. At the IMA headquarters, he was a standing committee, rural health, profession, consultant, anesthesiologist, medical legal advisor, pain and palliative surgery, palliative treatment, member mediation cell, Dharwad district, and so on. With these favors, I present before you Dr. Sivkumar Kumbar.
In single sentence, if we continue his curriculum, his talk will be only 5 minutes. Yeah, you can start, Shivkumar.
Thank you, everyone, and especially organized for giving me an opportunity to share my views. Next, please. To share my views on dying patient, the doctor, and the law. Dr. Suresh Baramat and Dr. Naurenge, they have made my job very easy. Friends, I'll just take you to a case scenario. You have a nursing home, your loved ones comes to your hospital in a gasping state. Yours is a maternity, but you don't know what for he is grasping. You admit him and you do best of your ability. After half an hour, you decide to shift into the tertiary care center. You shift into the tertiary care center with the intubation with ambu bag. By the time he reaches tertiary care center, the attending physician or a neurologist says that patient is partially hypoxic encephalopathy. Patient needs to be put on a ventilator. The patient was put on a ventilator for a couple of days and there is a brain death. In this case, you are in a dual mind, whether to declare death or not. In the meantime, after a couple of days, the patient dies. Since you do not know the cause of death, you wish to ask him for the postmortem, for which, since they are your loved ones, they don't want to go for the postmortem. What you can do in the scenario? If the patient doesn't die, if the patient becomes vegetative, persistent vegetative state, how you can push him to the comfort zone rather than the cure care? So if the patient dies over there and everything is all right, after a couple of months, you receive notices from 3 stages: medical council, yes, there is a complaint against you. There is a consumer notice, yes, there is a complaint against you. In the meantime, the criminal law may be knocking your door with the summons. With this scenario, I just go ahead. What exactly is the terminal or dying patient? Next slide. Next slide. Yeah. Sorry. Yeah. So many people do not know what exactly is the dying patient. The patient whose death is imminent, as well as those with advanced progressive incurable conditions, maybe in a terminal illness, maybe in age systemic disorders, maybe within the multiple organ failures, maybe within traumatic brain injury, where you think that probably his days are numbered or counted. And in a gross terminology, what we say that the patient would succumb within a span of couple of months. That we call it as a dying patient. Then, what are your obligations in such kind of a patient? As a medical professionals, yes, we have a autonomy of the patient, wherein the patient rights has to be respected, and we have to do to the best of our knowledge and ability for the beneficiaries. And non-malevolence means you should not do harm to the patient. You can categorically say that it is beyond my capacity, but I don't want to harm the patient. And informed consent is a need of the hour, and we have to respect the patient's requirement, and we have to respect the patient's consent also. And if you know that the patient does not have a curative, there's nothing wrong to push him into the palliative care. Among this, the Kerala becomes the #1 state in India where the palliative care is very well advanced. And also, the family involvement also very, very important, because you have to take them into confidence of what is to be done, what is not to be done. And the role of physicians is very, very important, because we have got a certain obligations toward the patient, to the society, and other things. What are the legal implications when you come across this kind of a dying patient? Yes, we have legal obligations being born in India. One is right to life and right to die. Article 21 of our Constitution always talk about these two things in Article 21. And passive euthanasia, which is legalized in India in 2019, modified in 2023 January, which I'm going to touch in another slide. And also the advanced directive, what you call it as a living will. Earlier, there were the days wherein the Western countries used to have a living will, but it was not there in India. But again, in India, the advanced directives are a living will is legalized. Then what are the challenges? Challenges and considerations when we talk about this dying patient. Yes, there is a cultural belief where religious and cultural beliefs can influence the end of life care. If the patient is dying, we have to be very, very careful. And access to care in India is limited because of the poor knowledge of the palliative care, and also a financial burden. and also the training and education, especially among the internists or physicians or intensivists, except intensive physicians, most of the specialists, they do not know about the palliative care. And also the legal interpretation is very, very important since you don't have a statute, but we have a Supreme Court directions. As long as the statute comes into picture, we have to follow the Supreme Court directions, but most of the medical fraternity do not know about these guidelines also. And many times it becomes misused by the relatives, maybe because of financial gains or because of the any kind of the prevailing conflict in the family. Then there are a lot of areas in this debate, active or passive euthanasia. Some argue that there is a thin line between the active and passive euthanasia, which you should not venture into such things. And the role of courts, Supreme Court role is the interpretation and applying for the legislative state, advice directives is subject of ongoing phenomenon even in the legal language. And also there may be a slippery slope, which you call it an argument. Some argue that legalizing this living will may be a slippery slope where it is eventually exposed to the encompass the non-terminal or non-voluntary cases. So what are the obligations of a doctor? What you are supposed to do when the dying patient comes to us? Yes, we have certain obligations. Are doctors as hospital bound to attend emergency patients? Yes, we do. We have an obligation. Is the obligation is the same to the government as well as the private? Many times, private medical practitioners, they tend to avoid the medical legal cases, think that probably there is a legal errors. But there are a lot of Supreme Court directions are there. Yes, who are also bound by that. And also, if the MLC, medical legal case is there, should the police possibility prevail first rather than treating the patient? Again, the legal formats will come to the last. First do the first aid and try to preserve the life of the patient. If the patient or relative do not have the money to bear expenses in emergency, what you should do? I'm going to touch upon this. Then the law clearly says that treat emergency first, no deposits, no consent is required. Especially in Pravan Kumar Mukherjee versus Ruby General Hospital. It was in the 2000 recent case where the patient who was a BTech student was crashed with a motorcycle and taken to the hospital, and he was insured for 65,000 rupees. And he pleaded, I have an insurance of Medicaid project, whatever it is, and you please treat me. And his friends also urged that, yes, we are going to have a sum of money, please treat him first. They took the patient to the hospital in the ICU. They started after 45 minutes or so. They said that you need to deposit some more money, for which the poor fellow, he said, I don't have money, for which he was shifted to some other hospital. But by the time he reached that tertiary care center, the patient died, and they declared him as a dead and alive. In this, National Commission awarded so much of money. And also in emergency critical care, doctors should discharge their social obligation to render services without waiting for the money or to the consent. This is a landmark judgment. This is an obligation on the part of the medical fraternity. Then one more is obligation to provide emergency or health care. This is Paschim Bengal Khet Mazdoor Samiti versus State of West Bengal. Again, the Supreme Court categorically said that because there was a patient fell from the train where the patient has a traumatic brain hemorrhage, and he was taken to the PSC nearby. And from there, he was referred to the specialized hospital since the beds were not available. Then again, he was referred to one more hospital. Again, the neurosurgeon was available. Ultimately, he went to the private hospital where he paid hefty amount. But when he entered the Supreme Court categorically said that the government is responsible for providing all those things, and the government has to be penalized to reimburse all those things. And one more very interesting case, a right to emergency care during the accident. Again, you have an obligation to look into this case very seriously. Doctors treating accident patients should not be made to wait by the court by repeated calling. Many times it does happen. We all attend to the court cases whenever summoned. We go there 10 o'clock. We wait there till evening 4 o'clock. Ultimately, the court is adjourned. But this, I don't know, judiciary is aware of it, but we cut a sorry figure. We leave our OPD and IPD. They come back late evening, and also your hearing will be in the next month, which may be like this only. Then the patient is admitted, and you wish to shift the patient to the higher center because they don't have a ventilator. How exactly you need to shift the patient? Stabilizing the patient is very, very important. if you do not stabilize the patient and shift to the tertiary care center, if the patient dies on the way, you will get a very sorry figure. And this is also one more very interesting cases where the relative said that they did not shift the patient immediately to the tertiary care center, so the patient died. The doctor said that since the patient was not stabilized, so we took some time to stabilize. In the meantime, the patient died. Hence, the court said that there was no negligence by not shifting the patient unless you stabilize it. How to shift a dying patient to tertiary care, sir? No doubt about it. We need to shift the patient to tertiary care by ambulance. But many times, especially in the taluk and district places, we know that ambulance is available, driver is not available. Driver is there, ambulance is under repair. Both of them there is no diesel or petrol. So in such cases, how exactly we need to shift the patients? This is a very, very landmark judgment, Sakil Mohammed versus Miss Dr. Parin Irani in the Parsi General Hospital. Cesarean took place, and intraoperatively patient had a cardiac arrest, and another station intubated the patient. He tried his best to revive, and ultimately patient revived. Since the patient was fighting with endotracheal tube, he extubated, and they shifted the patient to the Bridge County Hospital. But anesthetist, he accompanied the patient in his own car, but he was not there in the ambulance. By the time he reached the Bridge County Hospital, they said that people submit dilators sluggishly reactive. They labeled it as a hypoxic encephalopathy. The court said that it was a moral obligation on the part of the anesthetist who has intubated to see to that the patient reaches to the nearest theater in his presence. So the anesthesiologist penalized in this case to the tune of 4,10,000 doses. Make sure that you accompany the patient till the patient reaches the tertiary care. Many times in small nursing homes, who has to accompany? You don't find always anesthesiologist to accompany the patient. We have certain guidelines for that also. Yes, who should accompany the patient? Level 0, where the patient can be managed in the ward, but ultimately patients would ask that I want to go to a better center, please send me. That time you don't have to have anesthesiologist as a specialist for that. And level 1, there is risk of deterioration. So that time the paramedical staff and the trainers, especially in the CPR, should be accompanied by the patient. And level 2, patient at organ failure, where you need to accompany with the not necessarily intensivist, the one who is trained in the CPR manual should be accompanying the patient. Especially level 3, where we expect a respiratory failure or more than 2 organ failures, we need to a qualified anesthesiologist accompany the patient. That will save your life. If at all, they knock the door of the justice. So coming to the advance directive, very, very important. I'm going to touch upon that. As per the ICMA guidelines, advance directive is a statement made by a person with a decision-making capacity stating his or her wishes regarding how to be treated or not to be treated when it loses its such capacity. Okay, this is very, very landmark judgment which came recently. And the surrogate decision maker is a person or a person other than the healthcare providers who is accepted as a representative of the patients when he is not in a state of decision making. He can have a surrogate patient relatives to decide what to do, what not to do. And it is a legal document in India now. So the recent guidelines and advance directive living will, I would say that a new dawn in the care of the dying patients in India. In 2018, in response to a PL filed by the NGO that common cause, the citizen's right to execute is including the right to refuse a treatment in terminally ill patient or persistent vegetative state. The procedure was very, very cumbersome. They said that we have to report to the magistrate's judicial, which was very, very cumbersome. For that, nobody went for that. And again, Indian Society of Critical Care Medicine and the Common Cause, they filed an application to Supreme Court that make it very simple, accessible to the public at large. And here, again, they came in 2023 January, certain guidelines where it is acceptable to the majority of the medical fraternity and adhere to the decision-making active, and he can produce it to the district magistrate, or what we call it is a district DC. Okay. So it's a two-tier process. The hospital has to constitute 2 boards. One is the primary and secondary. So who are there in the board? The primary board, admitting physician, intensivist, any other specialist involved in the case. And secondary board, one member empaneled or approved by the DHO of that particular district. And he can be outside also from that hospital. Advance directive can be changed or revoked at any point of time. If there are multiple options are there, that latest one will be taken into consideration. The primary, that's what I told you. But the primary and the secondary board, they should give their information within 48 hours. Earlier, it was very, very cumbersome. But still, 48 hours in primary, 48 hours in secondary, it will be about 4 or 5 days. The patient with such kind of a treatment ratio, it's a cumbersome. Again, probably we need to know whether this guidelines will be in due course of time simplified. So these are advantages. I'm not going to touch upon this. Yeah. The historic judgment by Karnataka allows dignified death for terminally ill. Karnataka published the first and second suggest to the Kerala, wherein the Karnataka is the second state in Kerala to implement these directions. This will help the patients with no hope of recovery, patients with persistent vegetative state, and patients who no longer benefit from the life-sustaining treatment like a ventilators or inotropes. This is the advanced medical directive. Please do not have it. I will send a copy of this. Very, very informative, and I have made it very simplified. Yeah. Dying patient and the MCI rules. This is very, very important. Obligation to the sick. Though the physician is not bound to treat each and every asking his service, he should not only be ever ready to respond to the calls of the sick or the injured, but should be mindful of his character of his missions. Again, the prognosis, the physician should neither exaggerate nor minimize the gravity of the patient's condition. Again, the patient must not be neglected. These are the respective council guidelines. And again, the dying patient and the Consumer Protection Act, everybody, there was a hue and cry all over India, but still, as long as the PP Shanta was IM versus IMA is there, that we are into the Consumer Protection Act. And there is no capping for the compensation being asked. Even if you have paid 100 rupees for the hospital bill, yes, he can claim for the crores and multiple crores. And there is a capping for the consideration being paid by the consumer. Consumer is the patient. Okay, if the hospital, the bill is less than 50 lakhs, yes, he can knock the door of the consumer court of the district, the state, between 50 lakhs to 2 crores, and more than 2 crores is a national consumer. Since the most of the hospital, except there is a organ transplant, so probably the bill would be less than 50 lakhs, wherein all the districts, a patient can file a case from the place where he resides or works for the gain. If the cesarean is occurred in Gadag, the patient resides at Delhi, probably they can issue a notice from Delhi only, for which you need to go at Delhi and defend your case. And no penalty for frivolous or vexatious. Earlier, earlier CPA, there was at least a deterrent for the party to pay 10,000 rupees if there is a false or vexatious. But this is taken away in Consumer Protection Act 2019. And unfair trade practice, failure to issue a bill or receipt, disclosure of the personal information given in the confidence, this all comes under the unfair trade practice. And if the district court has awarded some compensation, 50 lakhs or 1 crore, and you are very much sure that with the best of your knowledge and ability with a medical legal consultant, you want to win the case in the state commission, you have to deposit 50% of the awarded money, then only you can go to the appeal. Even if it comes after 10 years, there's no negligence, what you're getting is nothing other than what you have paid. And also, every district has a mediation cell. When you know that, yes, you are going to lose that case, there's nothing wrong in approaching the mediation cell if the parties agrees and the case is referred to the mediation cell, wherein I am the mediation cell member in the Dharaud District Court, and you can have a give and take phenomenon by the both parties, and you can settle the issue. Once it is settled, none can go to the appeal. And what I've seen of late is the consumer courts, either in the state, the district, and national, they award the compensation along with the interest. They have got arbitrariness. They don't just interest 1% to 18%. They say that it would state from the day of the accident has occurred till the realization of the compensation amount. So this is a huge discrepancy in it. We need to know. We don't know what to do, what further that. Even the court recently judgments have come that there is no negligence, but on humanitarian grounds, on sympathetic grounds, you need to pay the compensation. I don't know whether the insurance companies will come forward to accept this kind of a claim because they have certain clauses. If it is in the exclusion criteria, you have to sell from your pocket. Yes, BNS and the criminal law. Whoever causes death of any person by doing rash and negligent act, not amount to culpable homicide, can be imprisoned for a term for 5 years, plus along with the penalty. But if the same is done by the registered medical practitioner under the NMC 2019 and registered in the respected medical council, the imprisonment for 2 years with the penalty. It is applicable only for the allopathic doctors, not for the BAMS or BHMS or physiotherapist or a dentist. But there is a hitch in this. 2017 and 117 and 1124, if the act causes a permanent vegetative state or a damage or deformity, yes, the imprisonment for 10 years, which may extend to the life imprisonment. I had a very stringent arguments with few of the lawyers in the recent past. They said that we file a case on the doctors if they becomes vegetative under these sections. You may prove it in the court of law. We don't know how long it will take place, but till then, yes, you will be maybe punished. Where this is stringent clauses are there. Because we have to balance ethical grounds also. As per the Hippocratic Oath as well as the Supreme Court judgments, we need to try the patient till the death. Yes, it is our obligation, but if the patient becomes vegetative, this is the penalty. But never ever get scared about that. We have a certain defenses for that also. The act done in a good faith in the new PNS, act done with accident without a criminal intention, act likely to cause a harm done in a good faith to prevent other harms, act done in a good faith for the benefit of the patient with the consent. So these are such things which will protect us in palliative care. Yes. Yeah. Last slide. Yeah, doctrine of double beds, very, very important, especially for the intensivist. The patient is in a ventilator, composers cause a death or respiratory depression where you fail to intubate, the law will protect you in this doctrine of double effect. If the patient refuses for the post-mortem, this is the standard format which can be taken to prevent the, if at all they are against the post-mortem. Yeah. Right to life does not include right to die, but the right to live with a dignity does include the right to die with dignity. This is what we conclude with the dying patient. Thank you, one and all.
Thank you, Dr. Shivkumar. It was a wonderful presentation, and end of life care has opened a big. It's a topic by itself. End of life care, and lots of regulations are trying to come into the field. Especially we being intensivists and all, we face this situation quite frequently. Patients on high vasopressors, young patients, but not salvageable. So very tough task, but I think communication will solve most of the problems. Any questions from the delegates?
Sir, is there any option like we can deny treatment a particular patients on their financial status if the patient is not in an emergency basis? For
Yes,
example,
yeah.
any fractures
Yeah.
or any.
Yes, you have a right to deny. You have a right to choose your patient whom you are going to treat. If they have financial constraint, unless it's an emergency, you can refuse your patients. You can refuse the patient to treat or get admitted.
The patient did not agree, like something like that. Like if
No, you have a right to choose the patient. You have a right to charge your fees. And you have a right to refer the patient to any given plan unless it's an emergency. As well, you can say that my bill is so and so in the hospital as per my this thing. If you are capable of paying it, you get admitted. Otherwise, don't get admitted. Yes, definitely you can refuse unless there is an emergency.
The bottom line is any patient who comes to your doors, at least secure the airway, control the breathing and maintain the circulation.
yes, sir. That's what
You will not be sued on that. ABC has to be done, then referred. As far as elective cases, you have got your choice.
Yeah.
If they are not willing for your bills or the way you treat, then they can go to other hospitals. But again, it should be documented. That's all.
It has to be documented.
These financial issues also has to be documented, sir.
Financial issues has to be-
Because the reason for my referral or denial, can it be financial issues?
Yes, definitely, yes. Otherwise, how do you run your nursing home? If there are 6 or 7 cases in a week, probably you might to close down an hospital.
Yeah.
Sir, it is as simple as that. If I can afford Taj Vivanta, I'll stay there. If I afford Ayodhya, I go there. I can't go to Vivanta and say that I'll pay Ayodhya charges.
Thank you.
Very
Sir.
simple.
Sir, one more doubt.
Yeah, please.
I'm an orthopedician. This scene occurred with me. A patient with a fracture femur admitted in my hospital, and I was treating him initially, but later on he developed pulmonary embolism. So he needed life-threatening the care, ICU care.
Yeah.
But I did not have ICU care. But I have counseled in the early stage. He may develop such kind of complications. You should be ready. During that time, they agreed. Later on, they were not willing.
Yeah.
And the situation escalated, and they were threatening that whatever treatment should be done in this hospital, since he is staying there since 2 days.
Yeah.
Now I was caught in a fix. What to do? They are not willing. I can't shift the patient against their will to another hospital. So what should I do in such kind of a situation?
See, there are two things, sir. See, if there are 1 or 2 Supreme Court Commission judgments also that stating that, especially one case in the gynecology, post-operative, they needed a pulmonary embolism, something like that, needed the ICU care for which I think the court says that unless there is a ICU, why did you do the cesarean? And there was a plea stating that if it is the case, most of the maternal hospital in India will shut down. Okay. And ultimately, what it need to bring to the notice, post-operatively, you need to be shifted to some other hospital. You have to be mindful, you have to tell the patient and record it in the same thing. The second one is, if you smell it, okay, probably going to the fat embolism also, you do the best of your best treatment and refer it to the tertiary care center, informing that I'm referring so and so patient, please, whether the beds are available or not, then only can shift. If you shift over there, beds are not available, it becomes anguish in the eyes of the public as well as the patient relatives. So in such scenario, document what you have, for which they have agreed. And in the best interest of the patient, there's nothing wrong in the patient where the ICU setup is there.
Yes.
Thank you, Dr. Shivkumar.
Sir,
Yeah, we are running short of time.
No.
Yeah, you can discuss with the Dr. Shivkumar other things. Basically, it is all about documentation. Thank you, Dr. Jayant, Dr. Suresh, and Dr. Shivkumar for your wonderful presentation. Thanks again. We close this session. Thank you.
Thank you, sir. Sir, I request the chairpersons to kindly hand over the moment to Dr. Shivkumar, sir. Thank you, sir. There are a few questions which are being posted on the Zoom meet. I will send volunteers to the respective speakers. If they can answer those questions, we will answer them on the Zoom meet chat itself. Thank you. We have a short break right now for tea break. It is for 10 minutes. The tea break is arranged opposite to the hall. I request the chairpersons to kindly stay back. I request Dr. Reshmi sir to please come and hand over the mementos to the chairpersons. Thank you, Dr. Guru Prasad, Dr. Rajshekar Ballari sir, for chairing this session.
Sir, as we are running a little bit short of time, I request everyone to please be there by 10 minutes. In 10 minutes, a tea break. So we are going to start the next second session in another 10 minutes, which is laws and Indian medical practitioners. Thank you.
Hello. I will request everyone to be back in the hall by 11:30. We'll be starting the next session at sharp 11:30. Thank you.
We request everyone to please come as soon as possible so that we can start our second session. I think we are already running late little bit. I request all the delegates who have finished their tea to please come and have a seat. So we are going to start our second sessions today. That is laws and Indian medical practitioner. So I would wish to call our today's chairperson for the second session, Dr. Vivek Thorai sir, Dr. Sandeep Prabhu sir, and Dr. Raju sir. Dr. Vivek Thorai sir is the Deputy Director of Department of Health and Family Welfare, Karnataka, and also is in charge of KPMA and PCPND Act and POXO Act. So Dr. Sandeep Prabhu, sir, is our very active IMA member. He is a past secretary of Karnataka private establishment, actively delivering across the states, entire Karnataka state. So we're coming to our next chairperson, Dr. Raju sir. Dr. Raju sir is a very good friend of mine and is a principal of KH Patel Institute of Medical Sciences and also is a HOD Department of Forensic Medicine and Toxicology. Welcome you all, sir. Over to you, Chairperson, sir. I request today's second session first speaker, Dr. Madhusudan Karigar, sir, to please deliver the speech.
Yeah, good morning, everybody. A wonderful first session. We are starting the second session. So the first speaker for this session is our very own past president of the IMA, Dr. Madhusudan Karegunur from Shiruguppa. Sir did his MBBS from WIMS Ballari and also his general surgery. He has worked as a past president of Karnataka Junior Doctor Association. He was the editor of IMA Focus, secretary of IMA KSS, and various other posts of the IMA organization. Presently, he is the chairman of IMA Karnataka Professional Protection Act, Professional Protection Scheme. And he is also a very philanthropist in his own right, having conducted various health awareness camps in more than 200 villages and 100 schools around Shiruguppa and Ballari district. He has conducted more than 35 health checkup camps. The adopted government school at Develapur received national award by the then President Sri Pranab Mukherjee ji. He has also initiated a service for our armed force personnel, which is not mentioned. He is recipient of various awards like the Bharani Chetna Award, National Award for Best Publication for IMA Focus, Med Achievers National Award for the year 2017 for national activities by social activities by a doctor, Best State President Award by the IMA headquarters in 2020, Community Service National Award by the IMA headquarters in 2023 in New Delhi. Other than this biodata, I would like to add a few words about Dr. Madhusudan Karegunur. A very active personality in our IMA, very well legally versed, always available for any sort of problem shooting or anything. A man to discuss your administrative problems as well as any other hospital problems as such. He was our president during the COVID times, wherein we had to endure a lot of administrative pressures, personal tragedies, and still IMA came out with a stellar performance under Dr. Madhusudan Karegunur during the COVID times. I am very glad to introduce him as a next speaker. Thank you, sir.
Hello. 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 ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಕನ್ನಡದಲ್ಲಿ ಆರಂಭ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರೆ ವೈದ್ಯನಾಗಿ ಕನ್ನಡ ಸಾಹಿತ್ಯ ಪರಿಷತ್ತಿನ ಅಧ್ಯಕ್ಷನಾಗಿ ಸಹ ನಾನು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. Today my talk probably on one of the very pressing problem that all the private practitioners are encountering, and I dedicate my talk to the victims of the air crash and also the unfortunate medical students at the PG Medical College, Ahmedabad. We pray for their soul to rest in peace. And as per the legality of the Gadag medical legal team, this should be the first slide. That is what they have instructed me. The second slide should be this. Yeah, I am following their legal aspects. Yeah, this is my topic, Karnataka Private Medical Establishment Act. If any good things are there, you give it to me. Any negative things, director is there in front of you, Dr. Vivek Dare, you can bombard with him. Yeah, this is the bottom line. Good people do not need laws to tell us how to act responsibly, while bad people definitely find a way around the laws. Definitely that is happening. That is a reality. Yeah, coming to the history of the KPME, Karnataka is the first state in whole of India to come out for controlling the private medical establishments. That is in 2007. Central Establishment Act, that is CEA, it came later in 2010. And it has seen lots of amendments, 2007, 2012, and 2017. Probably all of us are unaware that earlier we were not controlled. That is false. We were controlled under Karnataka Private Nursing Homes Act 1976. And after this, it has been repealed. And what is the purpose of the act? There were different purpose for the act in 2007. It was to regulate the registration and functioning and also ensure a minimum standards for the care. However, lots of sea changes have happened in 2017 amendment where they have a lot of other purposes to amend the act, wherein they have to enhance the transparency and accountability, empower the government with regulatory authority, display the patient charter, and also hand over the dead body of the deceased immediately without insisting on prior payment of their dues. Okay, what was the scope of the applicability? 2007, it was applied only to the allopathic private medical establishments, whereas in 2017 amended, extended to include the allopathy and also Ayush and other healthcare facilities. That was the change. And what was the consumer perspective of the amendments? Minimum staffing pattern and then emergency facilities to stabilize a patient. As we had discussed, it is obligation for every medical practitioners to treat the patient on humanity basis at the time of emergency, not worried about the medical legal aspect. So many things, so many people, so many associations are there to help you. We need to execute your medical ethics and maintenance of records which were earlier not there, and protect the patient's rights. That was the new change. And maintain transparency in treatment and billing also. The billing is the new thing that has come. And what was the government and policymakers' perspective? To collect the data, to fix and any loopholes in the previous existing law, that is the Nursing Home Act, infrastructure, quality management, biomedical waste management, it was either to not there, it was added. And first, the strict implementation of the, so many norms were floated earlier, it has come. And to come to the history of the amendments, it does like 2007, 2010, 2012, those amendments happened just without our knowledge or without any fanfare. However, the 2017 and the regulations rules which came into existence in 2018, lot of things happened behind the, I mean, not behind, a lot of things happened, brain churning has happened in 2017 amendments. Government made Justice Vikramjit's committee, which was formed in 2016, wherein IMA, FANA, FHIK, all other social activists are part of the committee. We had a lot of meetings with them, and IMA and other associations also participated. And IMA was the front line to suggest to the government, to the Vikramjit Samiti, that in one of my editorial in the IMA focus, which I had written, like it should be called as Karnataka Clinical Establishment Act. And we have, through IMA, we have written many more letters and communications to the concerned authorities, to the government, to make it as Karnataka Clinical Establishment Act, not the Private Establishment Act, which should include the government medical establishment also, as there in the Clinical Establishment Act 2010, where it is applicable to government and private setups except armed medical college, armed forces medical colleges. So our argument was healthcare is a fundamental right. Hence, whatever the rules made should encompass both the sectors, as mentioned in Justice Vikramjit Singh's committee report. The same committee took our suggestions and gave the report to the government to include both. Somehow, government did not oblige it. It went ahead with Karnataka Private Medical Establishment Act 2017 amendments, and it made one joint action committee headed by the Madhugiri MLA Rajanna, and it gave its report, where IMA was also a part of brainstorming sessions with the government. And IMA Karnataka State Branch has been a very key stakeholder and vocal critic of the 2017 amendments. A lot of critics we gave it to the government, and these criticisms definitely came out of a genuine cause. There are definitely genuine cause for the doctors to think about it. And so many doctors are very resistant for the change to new laws, and also fear of regulatory control. Somebody will control us. So major concern raised by IMA that time was a strong opposition for the provisions that include criminal penalties for errors or administrative lapses. Most of the people, all of us, may be unaware that 2000 Act included penalty as a punishment in terms of imprisonment. Maybe none of us are very serious about the 2007 Act. IMA and all the stakeholders made it. I have written in a red line where it has mentioned in the earlier 2000 Act, section 19, where the words the imprisonment for the term which may extend 6 months and with the imprisonment for a term may extend to 1 year shall be omitted. This is the major breakthrough, that is the change amendment had happened in the 2017 Act. That imprisonment clause is removed. So about the government price control, we vehemently argued with the government and made advise the government and we disagreed with the government's power to fix the treatment and procedure rates. And definitely it is agreed, and prices were fixed only for the government schemes. Private doctors consultation fee, it is left to us to fix it. And we are feared it would definitely compromise the quality and also closure of the smaller hospitals. And most of the time that fear is coming true now. And grievance redressal committees. See, so lot of things had happened. People had come, government has come with hospital internal redressal committee, taluka redressal committee, district redressal committee, state redressal committee. All those things were accepted by the government. Somehow we fought, and also we asked one question: what is the need of a parallel civil court already existing? So they agreed, and also there was no budgetary allocations for these things to happen. They have to come up with the budget which is already existing. So they listened to us. They amalgamated the redressal and also registration committee in the amendments. And our request to make any medical negligence, earlier medical negligence complaint was also there included in the KPMA Act, original Act before amendments. So that was the suggestion that was given to the government. We spoke to the concerned legal authorities, and also we included these words like any medical negligence complaint should be referred to the Karnataka Medical Council. That is there in the Act now. So operational burden, definitely over a period of time, probably all of us are speaking like as Suresh Badamat was speaking about, we should think and give an opinion sitting in a place of a person executing within his resource-based knowledge, resource-based availability of the resources, human resource, maybe it may be human resource or instrumental resource. We have to think in that perspective. So keeping this act, probably this definitely like medical records, how can we keep in a very peripheral, very remote area of the Karnataka? Very difficult. So definitely it adds to the operational burden, because human resources for all these things, manpower, very difficult to get in a rural place where to enter the medical data. And definitely IMA had actions. So we had protests against this. Definitely all of us are part of it. And to tell you that fight against Bengaluru Chalo, you know where it originated? It originated in Gadag only, in the house of Dr. R.S. Ballari's house. Myself, Dr. Yoganand Reddy, Dr. R.S. Ballari was the president of that time. So we thought, why can't we go against this? We took a decision. I made a WhatsApp message. It became viral. We had Bangalore Chalo, and later Belgaum Chalo agitations, and which leads to temporary shutdown of the PDs in 2017. That was a massive protest under the IMA leadership that has happened in the history of the Karnataka. Probably all are aware of it. And today's organizer, Pawan Patil, he sat for fast unto death. And Dr. Harish Delantapati is there. So he is a president-elect. He is also sat for fast unto death. So with those negotiations, with the dialogue, we have come with so many modifications in the act, and overall and above all, at present KPME registration is mandatory. That is the norm, and this is the history. I'll come to the practical aspects of KPME. And at present, registration is mandatory for all clinical establishments. For that, we have to fulfill certain norms given by the committee. And it should be done earlier. As we started in 2009, 10, 7, it was on paper. We have to do it online now. Renewal and registration, both are on online. For renewal of registration, kindly, every word is very important. All these things will help you to have a hassle-free KPME registration and renewal. Please note that registration after your renewal of registration has to be minimum 3 months prior to the due expiry of 5-year registration validity. This is 5 years validity. Even the Joint Action Committee had come with the plan. I was there in the Joint Action Committee meeting along with MLA Dr. Shivaraj of Raichur. Government has come up with renewal and registration for 3 years. We argued that so much of manpower to administer is very less in Karnataka, so make it 5 years. It agreed. It is 5 years now. To renew your registration, you have to apply 3 months prior. So what was the changes that have happened in? This is the reality. This is the thing that you have to know as a medical practitioner in the private sector. You need to know what is the law. You have to read and say this is the district registration and redressal authority. This is in the act. See, there are different. Act is different. Rules to form the act is different. This is in the act. The registration and redressal committee consists of the district DC, who is the chairperson. DHO is the member secretary who communicates with the members. The district officer is a member. Kindly read every word. The member representing Indian Medical IMA is a member. A member representing another association is also a member. A woman member shall have a graduate degree with experience of minimum 20 years in the field of social work or academic profession or medical profession. I'll not go in detail into that. Lot of intricacies are there while formulating these words. If you talk to me personally, I'll reveal those things. Okay, this is the act. What are the rules? Because rules are made. I'll just an example. The member representing Indian Medical Association. Which medical association? How it should be? This is in the rule. A member representing Indian Medical Association shall be the nominee of the chapter of association having the largest membership in the district. If a district has 2 or 3 branches, which branch has got the membership of highest? He has to. It is not the president of the association. It is the representative from the association. They have to. It is the responsibility of the Indian Medical Association of the district to send a representative officially in its letter added to the DC. Like I include this for the registration and redressal authority. Number 1. Number 2, the member representing another association. What is that another association? Shall be a nominee of a registered association representing private medical establishments having the largest membership in the district. It can be Ayush Association, it can be Allopathic Association, it can be a laboratory association. So one simple example, we need to get into the registration authority. What we have done is Ballari is we have formed one more Ballari Private Medical Establishment Association, BPMEA. Along with the IMA, we have registered it. All the medical establishment owners of the hospitals which have registered with the KPME, we have formed an association like Bengaluru and all other parts of the South Karnataka. We have FANA. So some part of the Belgaum and Bijapur, we have KPMEA. So they are the part of this registration and redressal authority. And one more woman member, how they have select, how they will be selected. See, so much of details they have given. Only for the relevant, for the purpose of the grievance redressal only, not for the registration, only for the redressal. She will be selected, recommended by 3-member committee consisting of DC, Chief Executive Officer of the ZP, Deputy Director of Women and Child Development. So all 3 people we have to recommend. Then they will recommend her name to the redressal committee. Her name will be there. Only when the cases comes for the redressal, she will come into the picture. And to all the knowledge of all the doctors, the each term of non-official member, all these three peoples will be for the 2 years term. Kindly remember, it is the responsibility of all these two associations to represent their representative every 2 years. And also there is, it clearly mentioned, shall not be nominated again. That mistake is happening in many of the IMA district, where they continues to occupy the membership post for second term, third term, fourth term, it becomes illegal. So any any judgment or any suggestions given by such committee will be invalid. So what are the functions of RNGRA? I'll call it as RGRA. So it can receive a complaint regarding non-compliance of the patient charter or private medical establishment charter, and shall inquire into the complaint and complaints pertaining to negligence, non-adherence to standards of, just kindly go through this, negligence, non-adherence to standard protocol treatments, procedures and prescription audit shall be referred to Karnataka Medical Council for inquiry and report within 60 days of the authority. If somebody complains, it is the duty of the registration authority, redressal authority to write this letter to the Karnataka Medical Council. It is not the prerogation of the patient to write the KMC. It is the work of the registration authority to write to the KMC that this comes under your purview. Within 60 days, they have to. Registration and grievance redressal authority shall, while investigating inquiry, any matter under this have the powers of, they have given a civil court trying a suit under the code of CCP 1908. They will have the civil court capacity. That means they can summon you to their court, they can verify your documents, they can give judgment. All the three things included in the civil court. And what are the offenses and punishments by the redressal committee? Running a clinical establishment without registration would be punishable for a fine of 50,000. That is it. That's it. And after giving, definitely they can't come just close our hospital by sealing it. They have to give a reasonable opportunity for being heard, why it has been opened and whether they have fulfilled all the norms. And if the complaint is given by the patient or relatives, only two people are eligible to give complaint to the registration authority or redressal authority, the patient and his relatives. They have not mentioned what all the who are all the relatives. It is not defined. Relatives. For overcharging only, this is the only complaint regarding the patient perspective. The second perspective is your establishment. That is a physical. Any lacuna is there in the infrastructure, or what is they have displayed in the charter, the services by the doctors, if they are not available, they also can give a complaint. And one if it is proved, like you have overcharged a patient, definitely they have given very good guidelines how to punish 1.5 times the overcharged amount. If there is 100 rupees overcharged, they will punish you with 150 rupees. Out of that, 150 rupees will be given to the patient, and out of the 100 rupees, 1/3 will go to the Arogya Raksha Samiti of the district forum for social work. If done 3 times in a year, the registration authority will make a written complaint to the concerned court for the cognizance offense. So it will refer that. If proved for 3 times, they have 3 times the overcharge. It will be given for 3 times. And patient charter or private establishment charter other than the overcharging. If it comes to other than the overcharging, a penalty of rupees 10,000 for the first non-compliance, 25,000 for the second compliance, and further time can again it will refer to the civil court, and the penalty may be extended up to 50,000. See, very important, no imprisonment. Okay. So all of us will think that is the highest, level where the patient can complain or doctors can have a redressal. Doctors also have one more authority. If you are not happy with the report or judgment by the redressal authority or grievance authority, you have an appellate authority to go for your complaints. If you are not happy with that, that authority is district director of the Ayush of the state, and also one clinician with post graduation in general medicine nominated by the state government, and Directorate of Medical, DMA. They form the authority over and above registration and redressal authority. So categorization of the hospital 2017 was different, and 2017 amendments, fortunately or unfortunately, it copied the levels from the Clinical Establishment Act, CEA 2007, wherein, so these are the levels of the hospitals, clinic, polyclinic with consultation, diagnostic support level of the hospitals. Exactly, they were copied from the Clinical Establishment Act. And one more thing, while we were discussing, this is National Commission suggested levels of the hospital. How much? 5 minutes? Okay. So National Commission set guidelines. Kindly visit Clinical Establishment Act of the center. There is a website. Beautifully, they have given how standardized treatment protocols, standardized treatment, structural implications of the hospital. Most of the time, we argue, probably Dr. Kumar, we were discussing, like when ventilator is not there, how did you operate? Was it right? No, they have given clear guidelines in the Clinical Establishment Act. You just go to the standard treatment guidelines. Surgery is different, ophthalmology is different, general medicine is different. How to manage a dengue fever, how to manage a fever of one day, how to manage, how to do circumcision, and what are the instruments to be kept on the bed side in the OT. Clearly, they have mentioned, nowhere they have mentioned you have to operate with the ventilator in your or ICU in your setup. They are the National Commission. We have to set these guidelines for the courts to hear. So this is the levels of the hospital. And definitely writing laws is easy, but governing is very, very difficult. Probably Vivek there knows it. Laws are there, governing is very difficult. So we have to register. This is the login ID. Always see through the KPMI. I want to request and tell you that kindly save your username and password. Most of the time we entrust our work to some technical work computer person. He will give all the enter data, everything. He will just in the end, he will give your KPMI certificate, which comes online to your mobile mail ID. Unfortunately, we don't keep the user ID and password. If it is lost forever. Because over a period of time, you need to enter so many details. If you want to change your prescription, consultation fee, it is 100 rupees. From tomorrow onwards, I want to make it 200 rupees. Yes, it is your right. But you have to enter this charge into the website of the KPME. If you have user ID and password, it's a 1 minute work. Inspection team will definitely, after this registration, accept your application within 90 days. That also your application, upload the documents, pay the DHO inspection certificate. It is for 5 years. And this is the new thing that has come in the patient's right. Patient charter, care, confidentiality, dignity, information, preferences, right to redress, patient responsibilities. These are all the patient responsibilities. And our charter, what is our responsibility? Transparency, honesty, patient friendly, effective communication. We need to have implementation of patient charter. And never forget to upload the visiting doctors on periodical basis. They will keep visiting, use the ID and password. Here, it will help. Upload visiting government doctors' names also. Rate list, it can be modified according to your thing. However, it should match with your displayed in the outpatient setup. And what is the impact of this? I am working in a very rural area where I don't have an anesthetist till now. It is a taluka place. I don't have an anesthetist. I don't have a physician. Only 5 to 6 obstetricians are there. We are working tirelessly to maintain the mother and child health care with the general surgery with my backup. However, such a rural area, I am finding is very, very difficult to comply with so much of norms. But we talk. Kumar was telling how to shift a patient to a tertiary care level center. How can we have an anesthetist? Because legal people may be sitting here. They take these points like how to shift a patient. It has to be with anesthetist. I can't do it in a peripheral. As Badamat said, we need to have a resource-based guidelines to be spoken at the ground level. We need to have it multiple approvals. That is a hiccup in the KPME. Multiple approvals have to take. Probably the pressing problem is fire NOC, how to get it. Very, very difficult. IMA is engaged with the stakeholders of health ministry, DGIP of the fire, and also the PSR, health department. So much of we are trying so much to easyfy it, looking at the Maharashtra, Andhra, so many fire acts we have read. We have our own things to come up in the future. And this is the problem, because fire things, they depends on one size fits all, cannot be applicable. We are fighting on it. Definitely psychological demoralization, definitely what we have seen in the Muskie. DH has closed and sealed the hospital without giving an opportunity for the doctors to say their words. This is what I always, myself, Dr. Sandeep, Vivek Tore, always we will be bombarding every day. So things are happening. Definitely it leads to raids, penalty ceiling, and the public shaming leads to a lot of stress among the doctors. That is happening. That is yeah, see, this is become integrated medicine, holistic medicine. Things are happening. KPMA should take into account, and the need of the hour is single window registration for the KPMA, not running around so many things. Strict formation of a district registration and result committee at all districts as per the norms, and renewal every 2 years. This is the work of the IMA. IMA should act, because we have all the powers, all the responsibilities to come out with a friendly KPMA act. Auto renewal, that is happening. I request the authorities to make it auto renewal, because if there is no change in the setup after 5 years, why you want to do all again, re-inspection, rechecking everything? You can just go ahead with auto renewal. And there are 3 expert committees that is recommended in the committee, in the act: infrastructure guidelines committee, price fixation committee, and protocol guidelines committee. All the 3, unfortunately, they are not working with the infrastructure committee. If it comes out with the basic infrastructure, what is resource based, I always write resource based report rather than Western idealistic model based. Okay, so it has to tackle mixopathy, small hospitals. Okay, great. Thank you very much. Thank you very much for the patience listening. So many things to ask within my purview. If I can answer, I'll, or else
Sir,
executor is there.
Sir,
He will
thank
take
you
it.
very much for the very nice talk and explanation of the KPMA Act. But as a chairman of anti-quackery from Karnataka IMA for the last 5 to 6 years, I see delegates from various districts. Please tell me, in how many districts do you have an active registration and grievance committee working? Please raise your hands. Which district, sir?
Koppala.
Koppala. Yes, sir. Any other district?
It is there in Yadagiri. I have the documents. We have it in Bellary. Very handful of
Where, sir?
redressal authorities.
Gadag.
Gadag.
Yes, sir. You have sent the representative every 2 years?
That has to be done.
Yes, sir. See, because there are multiple, almost 1,000 odd FIRs which have been filed in Karnataka by the persistent efforts of the government, the THOs, the DHOs. But till the registration committee is pressed upon with the DCs and it is formed, the court is refusing to take any action and referring back to it. There have been 3 very famous instances. One from Tumkur, where 30 cases were raided, went to the High Court, and High Court has referred back to the DHO. It is in cold storage since 2017. Second case, which was from Dharwad, which we pressed because he's a carpenter who is practicing, and it was raided prominently 3 times, and the case has been gone to the High Court. High Court has sent it back to come to the Registration and Grievance Committee. Even being the committee, the anti-quackery chairman, pressing it almost every month, still I am unable to proceed. Number 3 case is from KGF, where an exemplary work was done for anti-quackery, but unfortunately, again, the High Court has referred with a very strong noting that such rogues should not be allowed in the society to practice. Unfortunately, again, there we are stuck at the registration committee. Exactly as I was saying, this act is the only measure. You speak of anti-quackery. If you do not work in your districts, from IMA, we regularly write letters, and Madhusudan sir and myself and even Dorai sir, we are working tirelessly, requesting everyone to form the committees, but unfortunately, we meet a cold silence. Until this is there, this act can be used as a very strong weapon for you. If you
eradicate quackery.
Eradicate quackery, create a strong voice with the administrators, the DHO, DC, have every right to understand that nobody can harass you. They cannot close their hospital. Issuance of notice is a natural thing. Because if they find something and the act says that you are given time to correct it and report back, there is no closure. Even in the recent incidents in Muskie, because of the late reporting and late acknowledgement, there was a problem. Otherwise, it would have been there. Many a times, arbitrary decisions are taking place. Lastly, I would say the public support is unfortunately with the quacks. Sir can vouch for it. One case very near Dharwad where multiple fetus were found in the farmhouse of a quack, and it was established he's in prison, and when he gets bail, a procession has been taken in the town for him. So when we have the other side, being doctors and professionals, I think we have to use this act to our benefit and not fear it. Thank you, sir. Sir, anything?
Thank you. Thank you. Through IMA KPPS, we have 34 cases. Somebody was questioning, Badamat was asking me to tell the details. We have IMA is an NGO. So we can't make rules or regulations. We have our own rules. We have IMA Medical Legal Cell. Previously, Dr. Yogananda was the chairman. Now, Dr. Harish Delantabuttu, who is a psychiatrist from Bhadravati and also past president of Karnataka State Psychiatric Association. He is there. He is there. So anything you can address to IMA Legal Cell, definitely we can help you. You can write to the Karnataka Private Medical, KPPS. I am the chairman now. We have 34 cases at the district commission, state commission, one case in the national commission. We are fighting on behalf of the doctors. We have Hello partners, the very beautiful, good advocates, knowledge advocates with us. 3 advocates are there. We have retained them with us to fight your cases on behalf of the medical negligence.
My question is, who has to form the committees? Who is responsible for that one? If they don't do, what is the time limit and what is the action the government is going to take against them? Why it is not there in the KPME? If the doctor is not registered and all, he can be penalized, and any of the things the doctor can be penalized. But why the committee forming people are not responsible for these things?
No penalties mentioned in the rules or in the act. No punishment for the omission.
Good afternoon, sir. So I have a question. Last year in newspaper of Lower Karnataka, there was a statement from the health minister that each and every KPME clinics and medical establishments should be having a background of blue color for allopathic and green color for Ayush or Ayurvedic. Why it is not implemented yet, and why the patient is kept under dark from the government side, that to which doctor and which specialty is he going to get treated? Because of his urgency or his practice from over years, from 20 years, somebody would have definitely, as sir told, as one of the quack or someone, I didn't know, I'm not specifying. But they would have had a practice to go there, and every time he would have been taken care from his grandparents and all. So now the same practice is being continued. Some other his children would have come now. So that legacy is going to continue even after a year of implementing background and color coding. Why it is not implemented? Why the patients are kept in dark?
See, who is the redressal and registration authority? Who are the members? IMA is also there. Why can't we press the district IMAs to look into it? You call a meeting of the members just to implement it. See, any lag, what I told was, writing a law is easy. Execution is late. It takes time. Definitely, it is on the cards. It will be implemented.
Many districts, it's already implemented. Bangalore, Dharwad, Karwar, very prominently it is there. Only your district you have to.
Sir, good afternoon, sir. I have visited so many, almost 30 districts. Wherever I visited, they have displayed the board are either green or blue. That indicates that what the system of medicine they are going to take and whether they are qualified or not. That's what the demand of an IMA from long ago. We did it in a favor of IMA, and we want to categorize the system of the medicine. whether it is allopathic or Ayush. I think it is implemented. If it is not implemented, you can give a notice, give a press note to that DC or the DHO or the THO or to the state appropriate authorities. Thank you.
Harsha, am I right?
Yes, sir.
Yeah, he's Harsha Ji.
Yes. Sir, my question is, without establishing the committee, then the chairman will not have power to sanction the even licenses, and also he will not have any power to address the redressal or otherwise punishments. Whatever he does, it will be ultra vires or which is excessive law. Majority of the deputy commissioners, even DHOs, are acting actually like monopoly and a kind of thing. And being member secretaries and being chairman, their duty becomes to form the committee as per even general law. Because the act has clearly mentioned that committee has to be formed. Without forming the committee, the act is null and dead.
Yeah.
If we challenge it in the High Court, whatever the action done will be excessive. Of course, they will not be punished because they are bureaucrats. They are under the bureaucrats' coverage. So why can't this be addressed carefully? Because we are the educated community, we have redressal process, we have representation. Why can't it be made mandatory to form the committee so that our grievances can be addressed? Majority of the times, what I have seen, my friends have told that even audio alteram partem, that is to be heard, a person to be given a notice and notice period should be given to be heard what has happened. And then the case, if it is really, they can't take any decision, DC cannot take any decision, DHO cannot take any decision, should be referred to redressal. Otherwise, should be, if it is, should be referred to KMC. If that is not being done, then how will you expect the medical community to treat the patient in a peaceful manner, lovable manner, acceptable manner? How it is done? When the act is made to torture the people, like torture the stakeholders, then how stakeholders will help the country people, countrymen? So if you are sitting here and the government is sitting here to look after the health of the people, then first you have to pamper the people. Then you have to take the confidence of the people, form the committee according to law, and form a mutual redressal committee. It should be negotiable. It's a democratic country. It's not an autocratic country. I would like to send this strong message so that it should be done. Otherwise, civil agitation. Otherwise, people will agitate. See how doctors will take the revenge. They will definitely take revenge against the patients.
Harsha, we got your point.
Thank you, sir.
Like the bottom line is, we need to form the redressal and registration committee at every district. It is our responsibility. IMA should take a responsibility. And also, as you said, there was a case in Bangalore during the COVID period where there was a case at the Bangalore district for overcharging. It got quashed because it has not come through the proper redressal and registration authority. Even though there is a fallacy, there is a mistake, but it just technically it was got squashed. Vivek.
There is a redressal authority in every district. As far as this thing, that IMA or the IMA other representatives or the women redressals or non-NGO members, they should be changed every 2 years. That is a district decision, not by a state. And everywhere, almost everywhere, it is changing frequently after 2 years. But in some district, maybe IMA is inactive over there, or they want to continue their own members in that position, where these kind of problems are arising. But as far as law, the committee is not readdressed or reformed. That old committee stands good. That you want to be change of the IMA members means IMA should give representation, or DC as a chairman, he should form re-committees, or you can intimate the state. Nothing is happening. We are only having pioneer and we are not addressing it to the right, whether it is registration or grievance redressal authority or the state appellate authorities. That you please do it. Where there is a lagging in any district, Please do address that to the registration authority, to the state. Thank you.
Yeah, thank you.
Good afternoon to all the delegates. With the permission of chairpersons, I don't have a question, but some suggestion. I am attending this conference out of interest along with my son who is a surgeon. I am a husband of a late gynecologist and father of a general surgeon and father-in-law of a gynecologist. And myself is an advocate, A.M. Naik, residing at Ranebindor. At the outset, congratulating Mr. Congratulating Dr. Karinur for his efforts to draw the attention of the state government and in getting useful amendments to the Karnataka Private Medical Institution Act. At the same time, I am requesting him to take another task. So far, the speakers have quoted so many decisions of the courts, including the apex court. But I'm trying the honors of the doctors that all the doctors are under, and including the medical associations, are under the wrong notion that the doctors are coming under the purview of Consumer Protection Act. With all responsibility, I am putting these words. I shall draw the attention to the Consumer Protection Act 1986, and which was reenacted in the year 2019. Nowhere, either in the scope or objection reasons of the Act, there is no whisper as regards the inclusion of that so many decisions are coming in, even in the apex court, treating the doctors are also coming under the purview of Consumer Act, and even the advocates. But recently the decision has come, which is reported in AR 2024, Supreme Court page 2659, wherein it is held that the advocates are not coming under the purview of the Consumer Protection Act because of their specific role played by them and in uplifting the judicial system. Likewise, they have also observed that even the profession and professionals are not coming under the purview because it is solely meant for protecting the interests of the consumers who are hit by the businessmen and traders who are doing unethical practices. So there, the customers are moving there and the expenditure incurred by them before the consumer forum is very, very minimal. So everybody goes there. So the whole consumer commission is meant for protecting the interest of the consumers who are hit by the unethical traders and businessmen. But whereas the profession or the professionals, including the doctors, which has been observed by the Supreme Court, including the doctors, they have their own skill and expertise in their subject. And they are the authority to take their own decision depending upon the circumstances of the case to save the patient. So no doctor wants to kill any patient. Every doctor make his best efforts to save the life. So likewise, the Supreme Court in 1990 reported in the year 1996 Supreme Court, page 550, Indian Medical Association versus Shanta, wherein they observed.
Sir, we are running short of time. Please make it short. Sir.
Whereas the Supreme Court has recommended this matter to the Chief Justice of India, then Chief Justice, to reconsider that view. So in this regard, I am drawing the attention of the doctors and the association to move the Supreme Court to see that the doctors are not, doesn't come under the purview of Consumer Forum Act. Thank you.
Thank you, sir. Thank you, sir.
Kindly, organizers,
Sir,
kindly
can
the
I
details.
intervene here, sir?
Definitely, we can utilize their services for the IMA in the coming days at the state level.
And I am
Dr.
always
Madhu, sir.
accessible to serve the faculty of doctors in this regard.
Very obliged, sir.
Yes, sir.
Thank you.
Thank you, sir. Thank you so much.
Just to clarify, the
Request our chairpersons to.
hello,
1 minute, sir. Last question is coming.
hello,
Question, this is a correction. I
Hello.
think he's under a completely wrong impression that doctors are not included under Consumer Act.
Yes.
It was on 13th November 1995. VP Shanta versus Indian Medical Association, Supreme Court. It's a dark day for doctors, where it was categorically declared that doctors' profession is not mentioned in the Act, but it comes very much under Consumer Act. So that is a clear position. Afterwards, in 2019, this came up again, that medical professions word is not there. Again, they have clarified it is very much there, both by Kerala High Court as well as by Supreme Court. Now, next, it is only the advocate's profession which has been exempted for reasons not known to us, for which we have fought in the Supreme Court in the month of November 2024, that how you have exempted them and why not doctors. But this has been technically turned down by the Supreme Court, saying that it is an intervention application and not a separate positional suit, which we have gone in on behalf of Medico Legal Society of India. So we are in the Supreme Court. You help us, but please, the audience should not be under wrong impression that we are unnecessarily yielding to the pressure of Consumer Act. No court will take consumer case against doctor if it is not so. So it is very much applicable to the doctors. We are crying for that. You please, the profession of advocate should help us, which they are completely opposing us in the Supreme Court. That's
Point
the
taken, sir. Thank you, sir. Thank you. We are running short of
Hello?
time. Thank you.
Thank you for the suggestions.
Excuse me,
Hello?
last question. We fail to renew our registration or delay in registration, like renewal of registration, and we have issued a certificate during that time, is it punishable?
I could not get your point.
But registration is was due on in 2021, and we have failed to registration because some controversy was there whether it is you have to renew or not in IMA.
Which one? Karnataka Medical Council, KMC. That is a different question. That is a different forum. KPME. Definitely you are liable.
We are we can be punished if we have delayed in registration.
Punishable by whom? If somebody complains on you only, it will go to the redressal forum. Then it will take its course. It is your duty to renew in time. That's what I stressed. It should be done 90 days prior to that. And the ticket for me, it is in the act. If the inspection committee doesn't come and inspect your establishment within 90 days, it is deemed accepted. Deemed accepted.
I now
Hello?
request our chairpersons, Dr. Vivek Dore sir, Dr.
Hello?
Sandeep Prabhu sir, and Dr. Rajesh sir, to felicitate our speaker, Dr. Madhusudan Karignur sir. I know that all the delegates have come with a lot of questions in their mind. The beauty of
Hello?
this conference is that the speaker has
Hello?
to limit their discussion for 20 minutes and open for discussion for 20 minutes. If we stick to this time, I think we can cover all the topics in time. It's a sincere request to everyone. And there are certain online questions. I request our speaker to answer them with the help of our volunteers. Thank you, sir. Our next speaker is Dr. Meenakshi Deshpande ma'am. I request her to come over the dais and deliver her talk on PCPND and MTP Act.
Yeah, we are now into our second session. I'm very glad to introduce our second speaker, Dr. Meenakshi Deshpande, who did her POGS. She's a POGS. She's done her MBBS and MD. She is a POGS Secretary General, Senior Consultant, Obstetrician and Gynecologist. Past LLB in first class. IMA Pune, past President 22-23. Practicing since 30 years as high risk pregnancy consultant. Director, Vatsalya Hospital, Sindhgad. She is also a consultant in Krishna Hospital, Powd Road. She is a recipient of many awards, prominent of which are IMA Headquarter, Dr. Kanak Goyal Award 2018 for exemplary work in women's health and family planning.
Hello.
Aploki Award for work in women's social issues for consecutive 2 years. IMA National and Maharashtra State President Appreciation Award for 3 consecutive years. Rotary Award for social outstanding work. Her topic will be PCPNDT and MTP Act. Welcome, madam.
Yeah, thank you. At the outset, with deepest condolences for the interns who have been killed in this Ahmedabad plane attack. I wish to start saying thanks to the organizers for giving me the honor of being the only lady or woman speaker or faculty in the whole conference. So thank you, organizers. And yes, the PCPNDT and the MTP Act is the topic given to me. I would just like to ask in the audience, how many gynecologists are there? Oh, so quite a few. And how many gynecologists are doing sonography? Okay. So this talk is very much applicable to them. And plus, I would also like to emphasize that this talk is not only applicable to gynecologists, but also to the non-gynecologists in the audience. So please listen carefully, because I'm going to give you some little bit more take-home messages, because I want to start from the opposite side of the what doctors practice, from the law side. So whether these laws are a boon or a bane. I just take, yeah. So I start with the salutations to God of wisdom, saying that prevention is better than cure. And that is always should be our motto. We should not go into the clutches of the law. So we should try to do a preventive practice, and the most commonly done mistakes, we should be avoiding them. So first, I will just talk for 5 minutes on Medical Termination of Pregnancy Act, which has now been amended in 2020. So you can see now that how lenient it has become. Everybody of us knows, but even the non-gynecology should know that this Medical Termination of Pregnancy Act has now been extended beyond 20 weeks. It can go till 20 to 24 weeks, but the limitation is that it is only for the anomalies. One lady cannot come to your clinic and say कि I am 22 weeks, लेकिन मेरे को ये बच्चा नहीं चाहिए तो आप गिरा दो because now it has extended. No, there are certain limitations to this extension which has been given. Second thing, in upper limit from 20 to 24 weeks, it states there's a scope to increase the upper limit for vulnerable women. Vulnerable woman means the woman who is minor, the woman who is got his pregnancy because of rape, or who is because of molestation. So it is not for a normally, G2, G3 coming and asking you for an MTP. Then these are the changes between the two laws, how lenient it has been. Now you can see that only one doctor can sign till 20 weeks. Till 20 to 24 weeks, it is not allowed. And two doctors are required for the signature for MTP for 20 to 24 weeks. And after 24 weeks, for fetal anomalies, you can have it for certain fetal anomalies only after the medical board certifies it. So that is how the range of MTP, that is a legally allowed MTP, has been increased. And all this is done to decrease the unstable or illegal abortions which are occurring all over India. It is because we gynecologists refuse them because of the law. So you have to bring these MTPs under the ambit of the law, and then you can do it. Also, now this bill allows the unmarried woman. So failure of contraceptive, which was the indication which was used only for married women, now that indication can also be used for unmarried women. So consent you can take is consent of the partner. Husband is not needed at all. So consent of the partner is very well accepted by the courts for unmarried pregnancy to put the indication as failure of contraception. Only the thing which is bad for the doctors is a breach of confidentiality. That is a huge, big topic for us to debate, to talk. Only thing is you should not declare the name of the patient anywhere to anybody except to the nearby relatives. There is a violation with imprisonment for a year and a fine or both. The way out is you take a letter from the patient herself saying that patient does not mind revealing the name of her name coming for MTP. to any of her closest relatives or any of the relatives who are coming and asking for you can say details of the MTP done. But you cannot breach the violation, you cannot breach the confidentiality. Okay. So now I start with again, some few things that many years back, the laws were implemented. You can see the years, they were 1994 and 1996, 98. But how many of us knew about the laws till say 10 years before? Not many, because we were all into our practice, we were studying, and whatever we studied, we never studied law during our medical curriculum. We never studied and we overlooked the fine points of the law. And that is why this implementation started. When this implementation of PCPNDT Act and MTP Act started, say in 2015, if you all remember, it was this Ladli which has done so many doctors good, because this Ladli has made so many doctors aware of the laws. There were many, instances where doctors were taken under the ambit of the law, and then even small clerical mistakes, small clerical lapses became non-bailable, non-compoundable, and cognizable offenses. And that is how, pardon me for my voice, that is how Section 403, Section 23, Section 22, 27, 30, and Form F, all these came under the root cause of the problems. Is okay. And these were extremely dangerous. These were the points or clauses in the law which made the authorities wake up suddenly, and then they started giving us implementation shocks. Section 22 related to banning of advertisement. Till that time, nobody knew that small advertisement of a sonography center with a Krishna picture behind it gave a rise to the concept that you are advertising as a sex selection procedure, because that was not known to the doctors. And there are 2 or 3 cases who have been fighting that case just because of advertising such, for sonography clinics. Then we also have so many things under which doctor can be booked. On this, I will go a bit fast because these are all the law sentences under which people can claim and they can put you under jails. But this was the thing which we started in 2015 against the PCPNDT Act, indefinite protest. And do you know that time this study was done? This study was done in Pondicherry Institute, awareness of PCPNDT Act among undergraduate students of a medical college in Puducherry. So that time, nobody of the doctors, not even the gynecologists, not even the people who were practicing gynecology, doing deliveries, doing MTPs, they were not aware of these laws. And they were not aware that the doctors can be put under the clutches of the law. And that is why all these games started. Genetic clinics definitions changed. Sonography definition changed, which was not there under the ambit of the law. Any deficiency or any inaccuracy contravening the section was put under the clutches of the law. So now for PCPNDT Act, we know that maintenance and preservation of records, then register, which shows all this in a serial, the names, the addresses of the woman giving genetic counseling, subjected to prenatal diagnostic test, name of the spouse or the father, and the date on which they first reported. So this was the methodology which is given in the books. And if this methodology was not found to be put on the records, then only the people started putting cognizable, non-bailable offenses on the doctors. And how many families of such patients were penalized? Can you tell me? You were in Karnataka state. How many families were penalized? I think none. In Maharashtra, there's only one case, only one family out of so many cases who have been against the doctors that they have been penalized. And that is why we know that these penalties, all this, why it is only on the doctors, why it's only on the gynecologists or referring doctors or the doctors who are doing all this. They don't go to the houses of the patients. The patients are brought to them. So all these things, we should be from IMA side focusing on this pregnant woman when compelled by her husband or any relative to go for PNDT. It is we doctors who should be very much active against this clause. And unless we focus on this clause, our punishments are not going to get decreased. So again, appropriate authority had been given lots of powers. What happened in 2010, 2015, that the sex ratio started decreasing, and then the appropriate authorities started getting unlimited powers because of this. Judicial magistrate first class and metropolitan magistrates also got a lot of powers in punishing the doctors, closing down the sonography centers. And we normally that time, what we used to think that what is this word any? So that laws have to be reformatted. That laws have to be restructured. The F form has got to be removed from our clinical use because it is very much time consuming. It is a clerical thing. But what happened later on? Who got restructured? It is we doctors. Why we got restructured? Why we got reformatted? Why it taught us? Because of this High Court, Supreme Court judgment, which came in 2019. Foxy was the one who was fighting for 8 years against this F form and clerical mistakes. But constitutionality of section 23 of PCPNDT Act, complete content of F form is mandatory. This was the final Supreme Court judgment which came in 2019. And now it is up to us that we have to follow the law. We have to follow. So it is up to us to change our strategy and our thinking of how to go about our practice, keeping away the law from us. So we should be knowing that there's an advisory committee, there's an implementing body, and there's a policy making body in any law forming structures. Then what are the major lacunae in the PCPNDT Act? Where are the gray areas? So you should be aware of these gray areas. That very peculiar provision where accused is penalized even before conviction. Section does not classify offenses as minor or major. F form per signature एक ही रह गया ना मैडम, उसको जाने दो ना. नहीं, it is not allowed, but what is given is the form, and it's a Supreme Court judgment now. Protection to appropriate authorities for acting in good faith. Even if they seize your clinic, even if the seizure is there, they seal your clinic. There is no punishment on them for doing it abnormally or without any proof. Unlimited power of search and seizures given by appropriate, and no punishment ever given to the relatives. So these are the people who got acquitted later. This is our latest. Dr. Matrani, she got acquitted after 15 years of getting all the punishment. But yet the defamation cases, no doctor puts against the authorities. And that is why we are you can say the watchdogs. They are our watchdogs as to how we do a sonography. This is the do's and don'ts for the district authorities of the PCPNDT Act people. And in them, they have tick marked what is there in your clinic. So if you don't go according to what is tick marked, then they can give you a notice immediately. They can give you and our gynecologists, they are very busy in the practice. Our radiologists are also very busy. They sign the papers wherever they say. They don't read out. So that is our fallacy. Whenever they ask us to sign on the papers or anything, you please read what they are asking you to sign. Because one of the do's in this is they have to take a signature. You have to take your signature saying, ye fallacies aapke clinic mein mil gayi hai. So you don't sign on that. But that is not what happens. Our people sign on those papers and then they fall into the ambit of the law. So this is the PCPN, this is the sex ratio of that area, which makes the appropriate authorities strong and the magistrate people strong. So how can we go about it? And yes, still in spite of all this, we should also focus on the fact that even in spite of strict, law fermentation, following up, there are many unregistered centers who are still doing, quacks who are still doing. There are SDs being done in motor vehicles, and all these doesn't come under the clutches of the law because they are doing it in a very secretive manner. But the whole brunt of the checking falls on the registered centers. So how we are going to work on this? So first and foremost thing, remember that use of sonography like machines. We all use sonography. We all know that sonography can do sex selection, sex diagnosis. But how many of us know that there are many other machines also who can do such things, and that can be put under ambit of PCPNDT. This is the Maharashtra, which we have got the statistics, latest one. About 56 cases are pending still, and total 71 sonography centers were closed. So we took a consensus meeting in 2019 in Pune Gynec Society, IMA Pune, with Dr. Gupte sir, Dr. Naurange sir, Dr. Kalpana Baliwan, saying, what do you want? What does the appropriate authority actually want? So we want a hassle-free practice. So what was the remedies? These were the do's and don'ts given to our clinic center. But even if we follow them, there were lacunae in that. So what are the remedies for that? See, now these are the answers to the FAQs which were given by the appropriate authority when we put to them what were our problems, the practicing doctor's problem. First of all, it is not only the sonography, even the echo machine, color Doppler, 2D, 3D, 4D, CT, MRI, ophthalmologic, some A scan, B scan, then lithotripsy and anesthesia sonography. All these also come under PCPNDT Act. Do any of us know that? I don't think so. Because all these people who are doing not sonography, but they are utilizing these machines who can do sex diagnosis, they are not doing it. But these machines can do. And that is the reason why our doctors come under the ambit of PCPNDT Act. So remember that fine clause of PCPNDT Act, reading between the lines, say that it implicates a handheld Doppler, echo machine, echocardiography machine, color Doppler, CT, MRI, ophthalmology, A scan, B scan, lithotripsy and anesthesia sonography can also come under the PCPNDT ambit. Now, what is the requirement? Requirement is sonography should be done in a registered center, by registered doctor and by the registered person. So what do you mean by a registered center is duly registered before starting. Now, what our doctors do, the mistakes, is they give all the format, they sign the forms, they give it to the authority, and they start doing the sonography. Now, there's a gap of about 1 month or 2 months before they get, it is, 30 days or 90 days, what our previous speaker, Dr. Madhusudan, had told us, that when you give an application, if they don't come for checking for 90 days, it means that it is accepted to be registered. But till 90 days, if you do a sonography, it means that you are doing it in an unregistered center. Even if they accept the form, application form, you have to wait for their registration approval. And normally people don't wait. So it has to be duly registered before starting. Certificate is to be displayed at a conspicuous place. These are very small things, but these are not done at many places. At a conspicuous place means it has to be put in the OPD. Then board is essential. This particular, the size of the board with that particular, you ask your appropriate authority. Take a lecture of appropriate authority in your own cities and your own district areas so that you can know what they exactly want. And then copy of the PCPNDT Act latest should be kept in the book in the outside waiting room and also near the sonography room. Because sonography rooms may be at various places in a particular hospital. Then renewal, if you don't apply in the time frame, suppose your license for it ends at December, you have to apply 1 to 2 months before that. So if you don't apply within that time, then you can have that it may go, you have not applied for the renewal. So then registration is valid for 5 years. So in that 5 years time, you have to remember the date of registration is 1 month before to apply again. Then certificate, in those 5 years again, if the owner of the sonography machine changes, then you have to reapply. You cannot just give a letter to an corporation saying that now I am not doing the sonography, he is doing. And that is now you have to reapply. That is the main thing. For renewal, application has to be made 30 days before the expiry. New registrations, what happens if there is no approval or no rejection for 90 days? Then that is what you are told that it comes that it is deemed to be accepted if there is no communication from them for 90 days. And any deficiencies in the application, So then again, it is their responsibilities, appropriate authorities' responsibility to get all the paperwork done from you in time. Then unlocking the machine, only 2 minutes. Unlocking the machine should be done in their presence. That is also not done by many of our authority, our people. Keep the installation report. Additional, anytime you have got a new area, always get 2 or more rooms already authorized for that sonography. So that you don't have to go and apply all the time again. So intimation of changes in employees, that is there. You have to do it within 30 days or 7 days. Registered doctors means doctors have to be qualified. They have to have their own PG registration. Plus they have, if they are only MBBS and practicing, they have to have their sonography. Radiologist, locum, registered machines and troubleshooting. Troubleshooting is my last slide. So got any sonography machine which is not in use, inform the appropriate authority and get it sealed. Get the registration cancelled and then zero reporting is not needed. For conference, workshops and camps, this has to be taken special permission. Trainee should not be registered, need not be registered, but have to have MBBS and above. Please submit the list of all attendees with all AA. Trainer also has to be a registered person, and overseas trainer has to be registered with MCI, and such should be informed to appropriate authority. So with all these hints about how to come beyond, go beyond the PCPNDT Act, you can have a safe practice, a litigation-free practice, provided you know what is correct and what is you have to follow. And always give this information to all your neighbors and also your clinical associates. Thank you so much.
Thank you very much, madam, for the very informative talk.
Thank you.
Any 1 or 2 questions? We are running short of time. Somebody wants to be very brief, we can take 2 questions.
Madam, how many scan centers can a doctor visit? That is my first question. How many scan machines can an individual doctor have in his name?
Yeah. First question I'll answer that it was a first that one radiologist can visit at 2 scanning centers, but now, it has got to be a reasonable. My appropriate authority told us that there was one radiologist who has put 3 or 4, he is going to 3 or 4 places in the same 2 hours. So one place is at Gadag, one place is at Hubli, one place is at Dharwad. So you can see that it is impossible. So any common person would understand that if he is going in those 2 hours at 3 different places, then it is not acceptable. It has to be feasible and readily acceptable by the appropriate authority. Person can visit more than 2 scanning centers, but his name has to be there, the timing has to be there, and there should be no overlap. Plus, there should be adequate time given for traveling. And yes, one person can have more than 2, 3 sonography machines. All have to be registered in time. The thing is, what happens is, when a person is running a sonography center, he may be having a new machine which has come into his clinic. And when a new machine comes, it remains unregistered for many long months. And then that comes under the ambit of PCPNDT Act. That this is the unregistered machine which you are using. Actually, they might not be using it also, but it has been opened. So never open any new machine unless you call an appropriate authority, get an installation report, get an acceptance, and then you start using it. At the same time, whenever an old machine has to be disposed of, even that comes under the ambit of PCPNDT Act, because unless you inform the corporation, you inform the appropriate authority that this is machine we are not using, please come and seal it. Then only you can give a zero report of that machine. Yes, sir.
There are 2 questions online. Just we'll first finish. So there was one question to Dr. Madhusudan sir, that is fire safety registration compulsory even for clinics? So right now it is yes. So second was how is lithotripsy under PCPNDT Act?
Hello.
Yeah, I know. Lithotripsy, you know what lithotripsy is? A machine which searches for bladder and ureteral stones. So it is like a sonography machine only. Yeah, so there may be ranges, sir, but even that was what has happened for A scan, B scan of ophthalmology machine also. That association has to take that machine out of the PCPNDT Act. Then only we can allow that. We means the PCPNDT authorities allow that. Otherwise, nowadays, even they are putting that echocardiography. If you see, at present, this is going on in Maharashtra and Pune. Echocardiography, which is done by cardiologists, many times the assistants are doing it. Many times. Echocardiography is not done by actual cardiologists who are the authorized persons who are doing. The assistants are doing it. And they come under the ambit of the law because they are not the authorized person to handle that machine. And that is why we should, from IMA, I was having one slide after that. IMA and Foxy and IRA, I should focus that whenever you are announcing such certification courses, these technician courses, these technicians should also be allowed to handle the machines by PCPNDT law.
Thank you. Thank you, everyone. If there is a question, you can raise it in tea session.
Yeah. So thank you.
I now request our chairpersons to felicitate our speaker, Dr. Meenakshi Deshpande, ma'am.
I have a question, ma'am. When we have an ultrasound machine in a specific room which is registered, okay? So if we want to shift the machine to an OT, so is it allowed when the OT is within the same
That is what I told you. Why don't you get that OT also area sanctioned in your first application form?
Okay, the whole building can be registered?
Whole building can be registered.
Okay.
Then you can shift the machine anywhere inside.
Previously, we used to register the ultrasound room.
Correct.
Now we are giving to the hospital.
People,
you can shift to anywhere. And we are not booking a case. For that, you are shifting to from ultrasound room to
the authorized premise provided you at the
you can
time of
shift to
application, you mention
OT,
that.
you can shift to ICU, you can shift to your post-operative ward, you can shift to your recovery room. Don't shift out of the compound. Thank you.
I have a second question. It is mandatory. I'm being a fetal medicine specialist. We get prescriptions from the obstetricians. Okay, and it is mandatory to have a prescription for me to do a scan. Okay, and how long is this prescription valid?
If you are obstetrician, you own prescription. Sir,
I'm a fetal medicine specialist. I get prescriptions from the obstetrician.
no need.
I can write my own requisition on behalf of the obstetrician.
Unless we are suspicious about that you are doing a sex determination.
Okay.
Or you are in sex selection, you are doing it. We don't book a case. And if we have information about you that you are doing that, then we'll think that as a main point to think about the book a case. Thank you.
Okay, thank you.
Sir, one last question. Sir, regarding anesthetists who are using ultrasound machines in the ICU, what is the procedure to register their names?
You can register as a other specialty. Any specialist can book a panel in ultrasound, but you should not do a ANC scan.
Sir, agreed. If we give declaration that I am not doing ANC scans, will it be registered for even anesthetist?
Yeah.
So that
anesthetist, gynecologist, any other person, these three people, a gynecologist, radiologist, and sonologist, except these three people, any specialist can be register MPanel for an ultrasound. You are declaring yourself, and yeah, it has been circular has been sent to all DHOs. Whoever asked for it also they have sent.
Sir, please once more circulate it, sir. Thank you.
I will say recirculate.
Thank
I will recirculate to this Pavan, Madhusudan, our presidents. I have all presidents' name. I will circulate this.
This was a very common question asked by.
It is already there. You can give it for 100 rupees bond paper.
Yes, sir.
Saying that you are not using ultrasound for ANC. You are using for your specialty. That is the statement we require. That template is also there, and you can.
Thank you, sir.
You, sirs. Thank you, ma'am. It's a pleasure to invite our next speaker, Dr. Ravi Vangdelkar, sir, onto the dais, and he will be talking on the topic medical ethics.
We have the third speaker for the session, our very own Professor Dr. Ravi Vankadekar, our very dynamic, you can call him a very sports enthusiast, past national IMA president. He's a practicing surgeon and anorectal surgeon for the last 35 years, a health activist. Current position he's holding as a professor and head of colorectal proctology at the Department of SPH, Government Medical College, Dune. Chairman, IMA National Health Scheme and UG and PG examiner in general surgery. He was previously the treasurer World Medical Association from 2019 to 23, President SARC Medical Association from 2018 to 20. He was the past National IMA President in 2018, National Secretary IMA National Hospital Board for 2014-16, Executive Committee from Maharashtra Medical Council from 2011 to 16, member of the board of MUHS, National Chairman IMA Academy of Medical Specialties in 2013. Sir has presented various papers in national and international journals and conferences, authored chapters in multiple surgical books and recipients of many international and national awards. And as I mentioned in the beginning, he's a very sports enthusiast with avid mountain interest in mountaineering, a serious farmer and very adventure biker and a very voracious reader. Today we have Dr. Ravi Vankadekar before us to present the very good topic of medical ethics. Thank you, sir.
Good afternoon, everyone. I know it's quite late and we all are waiting for lunch. Thank you for the kind words, Dr. Prabhu. The chairpersons, learned chairpersons, Dr. Dore, Dr. Raju, who is the esteemed principal of this very prestigious institute. And it is always a pleasure to visit Gadag. I think this is my fourth time in this place and in this particular auditorium. And I'm extremely thankful for the organizers to keep on inviting me again and again, especially Dr. Pawan, who is like a younger brother, and I can't say no to him. And I'm very honored that KSB State President Dr. Chinawal, past presidents, Dr. Lakkol, many of my good friends from Karnataka, Dr. Kumbar, Dr. Shaila Kumar, the Medico legal Bhishma Pitama, and all our friend philosopher guy, Dr. Naurange sir, Dr. Meenakshi, who gave an excellent lecture, and before that, Dr. Madhusudan, who is a dynamic state and national level leader. Also, I had the pleasure of meeting my young MS and JDN friends, Arjun, Jyoti, and the entire medical office fraternity of IMA Gadak and nearby places. Once again, really thank you all the organizers, Dr. Shweta, who has been after me to send the PPTs and arrange the lectures. Dr. Binyal, who is the National Vice President. Today, once again, I will be talking on medical ethics. I'll be try to as short as possible. Already we are overshooting the time. This ethics is a topic very close to me, close to my heart, because I feel if we are sensitized enough in doing a ethical practice, there will be no need of such medico-legal conferences. We will not have such questions, answers, queries regarding PCP entity, Consumer Professional Act, if we are ethical by going by our conscience. ethics is defined in multiple ways. Basically, it is the discipline of evaluating and applying our moral principles, common moral principles in medical practice. So WHO defines it, our World Medical Association defines it. It is basically a dialogue between the humanist and the scientist. It also guides us in taking the right decisions. As we all are aware, in our medical practice, we face common dilemmas, and in solving those dilemmas, we can always take help of medical ethics, and they will definitely guide us to take a decision in the right direction. Many a times ethics, morals, values are interchangeable terms, we feel so. There is slight differences. Ethics is basically applied for all the professionals. So we have a code of ethics for lawyers, we have a code of ethics for architects, for example, and we have a code of ethics for medical professionals. It is different from law. This code of ethics is usually a voluntary code of ethics. They are different from your personal values or morals. Ethics tend to be more black and white. So, what is an ethic? You should not betray your friend. But you value your friendship. And the moral of the story is helping your friends is a good moral principle. These are multiple differences. Let us skip this. See, when I said personal morals or values, I know of many of my particular religion obstetricians who don't do MTP because it is forbidden. They feel that killing a fetus even is like, it is a hinsa. It is a violence. So they don't do it. So rules, regulations, values, moral principles, ethical, all constitute the medical ethics. We all are very aware that our medical science is not a perfect science. That is why lifelong we call it as medical practice. This practice word indicates that we are not perfect even if we practice for 10, 15, 50, 60 years. It is not a pure science like physics, chemistry, mathematics. It is an applied science. And whenever it is not a pure science, when 2 plus 2 always will never be 4. We need a set of moral values to guide in taking proper decision. So if we see a medicine as an imperfect science, if the body is like a science, the ethics will form its soul. A safety tool in our hands is to improve our ability to care for the patients. A sound knowledge of ethics will always help in taking good decisions which are beneficial to the patient and in today's context, safety of the doctors. So basically medical ethics is a knowledge to use, how to use our medical knowledge in that particular situation. So I was saying it is different from laws. So there are huge gray areas in our medical practice. Certain areas will be black, where they are unethical and illegal. Certain areas are totally white, where they are ethical also and they are illegal. They are legal also. But there is a huge gray area where it may be ethical but may be illegal. Meenakshi was discussing now about PCP and DT. We used to, before this act was changed of MTP, we used to always face this ethical dilemma that we know that there is a rape survivor who is having pregnancy. There is a pregnancy with lot of incompatible anomalies. What to do? So ethically, you are right. that we knew that we need to terminate this pregnancy, but legally it was not allowed. Similarly, there may be unethical things, but which are legal. Say a disclosing HIV patient's identity or disclosing MTP patient's identity. That way it is unethical. But if the law says that you have to disclose it, it becomes legal. So hence there is a gray area where ethics guides us in taking the right decision. And why we need to change. 2-3 main things which have changed over last 20-30 years in the medical practice. One is previously there was a vertical relationship, a paternalistic relationship between the physician and the patient. The doctor was taken as demigod and he was never questioned back. So it was a vertical relationship. Doctor telling one thing and patient following it blindly. Now this has become a horizontal relationship. The patient is going to question you. And that is going, there you need your ethical dilemmas are coming, which I will go through later on. Resources allocated for health are becoming scarce. Their requirement is increasing. There again, you need follow ethical principles to allocate resources. All these things require medical ethics. And when I said the vertical relationship is becoming a horizontal relationship, it means giving up of the power of the physician. There are few other things also which is encroaching upon the clinical autonomy of a physician. Say an insurance company now decides upon whether you can admit or you can operate upon a patient. Here you need a solid backup of medical ethics. Once you are on this solid ground of ethical, always solve the query and say that yes, these are the 5 reasons where I need to admit and I need to operate. Previously, this situation was not there. Also, newer technological advances, multidisciplinary approach, all these require a very sound ethical background. Hence, the need of ethics. Again, that is why we take such conferences, rising litigation. This is the unfortunate journey when probably Dr. Naurange sir started his practice. He was a healer. He used to treat the patient as in whole. Then maybe it was our generation where we became only doctors. We started treating the diseases. I am operating on an inguinal hernia. But now things have come to such a pass. We have become medical technicians. We don't even see the patient. We treat the investigations. Abdominal pain patient comes to my OPD, even touching his abdomen, I send him for a sonogram, see a silent gallstone, then I advise a lap poll. This particular thing needs to be changed. And that is why the need of ethics is more and more. Another thing which has changed over the years, previously, the golden generation of our senior teachers used to have clinical based medicine. In my experience of 50 years, I feel that this is appendicitis. Today, it is evidence-based medicine. But is only evidence-based medicine totally useful for the patient? We have to find a right balance between clinical-based medicine and evidence-based medicine. And how can we find the right balance? Is the fulcrum is medical ethics. That is why need for ethics. Ethics form the cornerstone of doctor-patient relationship. And if you have good doctor-patient relationship, no need of any violence against doctors or any litigation against doctors. Good doctor-patient relationship will improve the doctor-patient relationship, and again it will stop the violence. It will also, good ethics is always good business. Remember this, in the long term, Not going after short gain measures, doing unethical practice will always land you in some kind of trouble. So we all say good communication, good documentation, your good knowledge, good skills, ultimately, but the soul is ethics. When I say soul, it is conscious, it is your antaratma, it is your inner voice, that whatever I am telling the patient or doing to the patient is good. Because only you and you know that whatever I am doing, whether it is right or wrong. And as I said, safe is always sexy. Ethics will prevent violence, will prevent litigation. Hence, be safe. Practice ethically. I can skip through or just run through these slides how ethics is not something new. Since medicine was discovered in all systems of medicine, maybe it Indian system, Chinese system, the Egyptian system, the Greek, Roman system, everywhere there was code of ethics for doctors all the time. And later on it was codified. World Medical Association, which was formed in 1948, basically was formed at the backdrop of the atrocities committed in the Second World War, where unfortunately German physicians also played a very bad role. Hence, it was much needed that yes, ethics are needed. And after the infamous Nuremberg trials, WMA came out with first International Code of Medical Ethics, which we commonly call as Geneva Convention or Geneva Declaration. Then we had Declaration of Helsinki, which is for medical research. And now we are governed by the National Medical Commission Code of Ethics. Multiple Code of Ethics for various issues, torture medicine, ethics in conflict zones, all are available on our website. Remember, but ethics is always a dynamic and it's a living document. You can't have a set of ethical principles which are totally solid. They need to change as per the circumstances. This is what there are various theories. We all know this is the common theory of principalism where autonomy, malfeasance, beneficence, justice, which I mentioned, equitable distribution. We all know this. I will just go through it. First, do no harm. These basic principles, even if I say that ethics is a dynamic, ever-changing, the basic principles will always remain the same. Newer challenges will come. We will have to face them using the basic principles. We should always act in the best interest of patient. The patient has autonomy. Remember this, it is his body, which usually we doctors tend to get very annoyed, very irritated if the patient asks us 100 questions or even 10 questions back. Please avoid that. Even if I buy a mobile, I search on Google, I ask my 10 friends, I ask my children which is the best one, and then I go to the shop and then I ask another 10 questions to the shopkeeper. If I can do such a thing for a dead object of mobile, if I am suffering from an illness and if I am going to Dr. Prabhu, I am bound to ask 50 questions. Dr. Prabhu should never get irritated. Autonomy of the patient has rights, it is his body. So all patients have rights. Of course, they have responsibilities also. These are the various rights. Justice, again, for a emerging economy like India or a developing country like India, where we have limited resources, how to allocate the resources, whether we are going to allocate more on the primary and secondary healthcare, or we are going to spend the limited resources on tertiary healthcare centers like building all India institutes only. No, our primary and secondary healthcare should be the primary duty of the government. Few more things are respect, truthful, honesty, informed consent. Again, consent is one thing. I'm sure somebody must be taking a lecture in this whole conference on consent, but consent is very, very important. Nowadays, in all the developed countries, it is an informed dialogue. Say, I can quote an example of Israel. Each operating doctor has to spend minimum 24 minutes. The whole interview with the patient has to be recorded. It has to be typed online in real time. Even for a simple procedure. People have reached that stage and we still take blind signatures. Don't do that. If you are ethically correct, if I know that the patient really has appendicitis and not colitis or ureteric colic, and still I am advising appendicectomy. If I am ethically correct, doesn't matter if I can video record and explain to the patient. That is the importance of ethics. These are the main problems in clinical ethics, especially now if you'll see terminally euthanasia or physician assisted suicide, what we call as now, which has come into our country also. I'll just run through this. We follow this, still following, even though from MCI we have shifted to National Medical Commission. The code remains the MCI Code of Ethics. Biomedical Research Guidelines by ICMR, Mental Health Care Act, your Patient Right Charter by the National Human Commission, End of Life Care, as I mentioned, euthanasia, organ donation. Yeah, I'll just finish. Female, we can just skip this, as I said, Declaration of Helsinki, Declaration of Tokyo for preventing. I can just skip this. Physician's Pledge for the medical profession. This is by WMA. International Code of Medical Ethics, which I was very honored to part for its major revision 2 years back. In future, what we are going to face, ethics in the world of social media, very important in augmented artificial intelligence, telemedicine, robotic surgery, whether we should be guided by professional ethics or business ethics. That is very, very important from an organizational standpoint. Ravi Wankhedkar runs his own doctor-owned hospital, so I am governed by Code of Ethics. The moment I form a public limited company, I am governed by a business ethics. Then I can advertise on the highways. I can do anything. I can give cuts and commissions because it is part of my business promotion. So this dichotomy has to be addressed. That again, Consumer Protection Act, whether he is my patient or whether he is my consumer, all this thing, as we know that NMC now has integrated a ethical ATCOM module in the undergraduate curriculum so that the UG students are sensitized. A small slide about National Medical Commission, which we have been fighting. But today, the nightmare about NMC is coming true in the form of mixopathy, where we oppose the clause of mixopathy and we were fearing that in coming 10 years, we will have a hybrid doctors. And that exactly is what is happening. Hence, someone needs to tell NMC, which should be protecting the medical profession like the Bar Council of India does, that they should first do no harm to the modern medicine profession. But united, definitely we can oppose this. I always say our association is like the skin. We may are coming from different specialities, brain, heart, stomach, bones, but our association, which covers the entire body and protects us from most of the assaults, is our mother organization, Indian Medical Association, and our strength is in our unity. And on a last slide, which I always say, if you want to know ethics, read Mahatma Gandhi, follow Father of the Nation, that the earth provides enough for every man's need, but not every man's greed. If we follow this simple principle in our life, we will be doing ethical practice. Thank you. Thank you for the patient listening.
Yeah, thank you, sir. There's one question from the online, like the dilemma they have asked, like what is good for the patient and what is good by the book? Which will you prefer?
Exactly. If you'll follow the particular ethical principle, see if let us have a very practical example. Say I practice in a small place. I don't have enough facilities. Yes, in the book it is given that you need a neurosurgeon to remove an subdural hematoma in a case of accident. There is no neurosurgeon. Fortunately, now CT scan has come. And I feel that if he is not operated within next 1 hour, he is going to cone and he is going to die. This is an ethical dilemma. I need to, if I follow the book, I need to go to send him to a neurosurgeon, which is 3 hours away. So I operate upon him. Even the courts will say, yes, in the interest of the patient's life, I have taken an ethically good decision.
Yes, sir. So there's one more question for Dorai, sir. Once we apply for our registration for the clinic, is the DHO acknowledgement sufficient to start practice, or should we wait till the certificate is issued?
In KPME section 3 says that it should be intimated and practice can be started. But it was for the 2007 from the Nursing Act to KPME Act. But better not to start the practice after the till registration. Thank you.
Any other questions? One or two if you want. Anybody, sir?
Nothing, sir. We heartily welcome our IMA National President, Dr. Dilip Banosali, sir.
Sambalo. Shit.
So we'll conclude this.
All well, sir. All well.
Dilip bhai, theek hai kya?
Okay,
conclude
thank
the
you,
session, sir.
Dr. Ravi Vankadkar, sir. It was very nice session. Now I request our chairperson to felicitate Dr. Ravi Vankadkar, sir. Thank you, sir. I request Dr. Nagnur, sir, to come and felicitate our chairpersons. Thank you, sir. Thanks a lot, Dr. Nagnur, sir. And I really thank our chairperson for this session, Dr. Vivek Durai, sir, Dr. Sandeep Prabhu, sir, and Dr. Raju, sir. In a small announcement, we are having a banquet night today at 7:30 p.m. Like at Utsav Bhavan. The link of the location will be shared soon in the group. So we hope to see you all by 7:30 today evening. So the next session, the third session starts at 2 p.m. post lunch. It's quite interesting. So I request everyone to please finish it off and come as soon as possible. By 2 o'clock, we are going to start it. The session 3 will be like doctor, police and court. There will be a moot court also. So I request everyone to please come as soon as possible by 2. Thank you. All. I think it finds little bit difficult post lunch session to hear the all sessions, but all we have got a very interesting one more session from all three good speakers next by in another 10-15 minutes. So before proceeding to our session 3, we'll do a small inauguration ceremony of our today's scientific session. I wholeheartedly request Dr. Dilip Banusali sir, President, IMA, National President, Dr. Chiniwala, VV Chiniwala sir, President, IMA KSB. I wholeheartedly request Dr. GB Pitnal sir, Vice President, National IMA, and my father, Dr. R.S. Ballari sir, to escort Dr. Dilip Banusali sir on the stage to for a small inauguration ceremony of the scientific session. I request all to give a big round of applause for our National IMA President, Dr. Dilip Banusali sir. Thank you. Now, I request Dr. Dilip Banusali sir to address today's gathering. Kulkarni, Organizing Chairman, and State Secretary, Dr. Pawan Patel.
Namaskar. I deem it a honor and a pleasure to be here amongst you to inaugurate this IMA Medico Legal Conference being held in Gadag. I'd like to thank Dr. Radhika Kulkarni, Organizing Chairman, Dr. Sudraju, Secretary IMA KSB, Dr. Pawan Patil, President IMA Gadag, Dr. Tukaram Soni, Secretary IMA Gadag, Dr. Arvind, Organizing Secretary, Dr. Bhim Singh Somsekar, Treasurer IMA Gadag. And then, of course, our Vice President, Dr. Bidnal sir, and Dr. Chinnavar, State President. Well, it is a very important conference which has been hosted by the IMEC Gadak. I'm sure in next 2 days, you will be enriched about medical. See, we have been facing so many medical level cases in our practice, day-to-day practice. And conferences like this makes us understand what we are facing day in, day out in our practice. So I'm glad that I'm here to inaugurate this. And I think in my next session tomorrow, we'll be talking more about what IM is doing. So I wish all the best. Thank you very much.
Thank you, sir. Thank you, Dr. Dilip Banusali, sir. So we'll already, I think we are delayed by half an hour. We'll start with our third session. Before for that, I request the chairpersons for the session 3, Dr. G.B. Bidnal, sir, Dr. Mantesh, sir, Mantesh Patil, sir, and Dr. Shekhar Sajnar, sir, to please come on the dais. So I request next speaker of the session 3, first speaker, Dr. Senthil Kumar, sir. Request our chairpersons to introduce our speaker, Dr. Senthil Kumar, sir. A small request, whoever is standing outside or had lunch, request everyone to please come to the auditorium as soon as possible.
Hello. It gives me a great pleasure to introduce Dr. J. Senthil Kumar. Sir is from Tamil Nadu IMA. Yes, sir is holding the post of PPLLS chairman. Sir is also heading medical legal committee member. Sir also is Tamil Nadu Ophthalmic Association medical legal member, NABH principal assessor. Sir holds the office for district ophthalmic surgeon for 8 years. Best Doctor Award, Tamil Nadu State in 2017. Best Performance Award, Tamil Nadu State in 2018, 17-18. And Best Doctor Award from IMA National Headquarters, South Zone, 2019. Thank you. We welcome Dr. Senthil Kumar.
Thank you, sir. Before starting, sorry, forgot a small thing. We would like to introduce our today's chairperson. First, I would like to introduce our senior most surgeon, Dr. G.B. Bidnal, sir. Sir is presently a vice president of National IMA and is also a past president of IMA Karnataka State and is a very good surgeon at Gadag, practicing Gadag since 3-4 decades. So next is our Dr. Shekhar Sajnar, sir, and is also a senior most surgeon at Gadag. Sir was practicing at Gadag. Dr. Mantesh Patil, sir, Mantesh Patil sir is a HOD, presently HOD Department of Orthopedics, K.H. Patil Institute of Medical Sciences. Thank you. Mike to you, sir.
Good afternoon. Even though the audience number is very thin, we welcome our speaker, Senthil Kumarji. Please go ahead, sir.
Good afternoon. Thanks for the introduction and thanks for the opportunity, sir. Present my topic by giving 3 examples. So which will make us understand better. So what is a medical legal case? A case of injury or ailment in which investigations by law enforcing agencies are essential to fix the responsibility regarding the causation. Or a medical case with legal implication for the attending doctor. Legal case requiring medical expertise when brought by police for examination. So I start at first give the first example. So information to police. And if the same patient goes to the optical, 100 rupees is made off because the patient is getting the glasses from the same center. The patient didn't want the glasses there, they went off. After 2 weeks, the patient's attendant entered the hospital. They demanded for a prescription, saying that prescription was not at all given to us.
So then the people told, okay, we'll inform the doctor and we'll get the duplicate prescription. So before that, since it was getting late, so the patient started creating a trouble and shouting in the reception area and all other things. So though the center has an audio-visual system, recording system and other things, the doctor tend to ignore. She thought, okay, why to create a trouble? Let us ignore it. So after the patient didn't collect the prescription, he went off. After 1 week, she got an advocate notice stating bills are not given properly to me and excess of charges were collected. Instead of putting like charges were weighed off for the patient who gets the prescription, excess charges were collected from the patients who are not getting the glasses from their own center. So this is against ethics. This is an financial damage caused to the consumers. These kind of things were, a lot of things were written. So I asked the doctor, see, before you had an interaction with the patient and he had created a problem, did you give an police complaint? Doctor told no. So these kind of things should be avoided and we have to make sure like it is in our favor. Create a document. You need not proceed the case or other things. Create the document. Okay. So when to inform in a case of an general practice. So these are the conditions where it is mandatory to inform and it is not limited to injury, burns, vehicle accidents, industrial, unnatural accidents, electrocution, death due to snake or animal bite, poisoning. Oh, sorry. Broad death. Then illegal abortion, suicide, drowning, dowry death, woman within 7 years of marriage, rape, sexual offenses. Mandatory reporting, we need to think of POSCO also. Unclaimed newborn, child abuse, death within 24 hours of hospitalization without arrival of diagnosis. Drug abuse, death in police custody, cases referred by court. So in medico-legal cases, though we have to inform the police, the priority is providing emergency treatment and meticulously documenting the case. There are several landmark judgments, including Paramanand Katara versus Union of India, which insist on providing emergency treatment. And it is also the right of the individual, Article 21, right to life. So how to proceed? As informed, emergency treatment is first. That's the first thing. Register as a medico-legal case if not registered already in order to avoid duplication. Have a medico-legal register and intimation register. The details in duplicate or triplicate. Obtained informed consent. Fill all the columns. It has to be named, dated, and signed. So we'll get into the details. Okay. This is a model prescription. So don't forget to mark the identification marks of the individual, give an AR number, mandatory points or the time of interaction brought by. In case if a police has brought, you have to mention the name, number of the police and station involved. Place, date and time of accident, number of persons involved, examination details. So if injury present, details and nature of injury, weapon or force used, duration of injuries, avoid abbreviations and overwriting. If there is a need for correction, do that with sign, date and time. So this is the second example which I wanted to tell you. Interaction with police may not be comfortable always. Sometimes they get us into trouble, and sometimes there are incidents where they also get into trouble because of the procedural lapses. So once I was called to a district court
for a case where I had to give an opinion regarding the nature of injury. So as a routine things were asked for, and at the end of the case, the magistrate sitting asked me, did the police inquire into the details of you? So it was very early when I joined service. So I thought inquiry means I had done some wrong or something. So I suddenly told, no, sir, police didn't inquire me. There was no need for that. And then when I came out, they told whatever the matters which are presented to the court, there is a mandatory thing for the police to make sure, like even maybe my details, my working thing, where I am working, my professional the duties and all other things. And regarding the nature of the case, they have to inquire, make an report. But most of the time, what happens for this small kind of cases, police itself, they will, because they know they only get that wound certificate from us. So without an formal interaction, they write an report that inquiry was done on this date and time, and we had got the details, so and so. They get the details. And when it was asked, I told no. So, but luckily, like nothing happened to him. So the register, keep a register. The register has to be properly numbered, documenting the total number of pages in the first page. Register under proper custody, to be kept in cupboard with lock and key. So we had already seen details about consent. So I want to stress one point. In an unconscious patient, when there are no accompanying people, so you can get the consent from nearby relatives or nearby patients, attenders, from other doctors or staff. In case if policemen are present, you can get an consent also. So it's not mandatory in cases where examination was done as advised by court. For post-mortem, relative consent is not mandatory. Okay. So when a police brings a patient, so no doctor, whether in government service or private practice, no doctor can refuse the examination in a medico-legal case. So we already seen. So giving a first aid treatment, that's mandatory as per our clinical establishment guidelines also, it is mandatory. So this is well established in Paramanand Katara versus Union of India, Paschim Banga versus State of West Bengal. So what are the document policies in a medico-legal case? So we had seen the MLC register. We need to have a police intimation register, broad-head register, triage register, nominal register, SOP, and staff training register. This police intimation register is a model case sheet I got from the net. Okay. So we have to mention the AR number, date and time, name and address of the person concerned, MLC details, whether it is accident, poisoning or assault, outpatient, inpatient, or whether the patient was referred to. This is important because many a times after giving the intimation, policemen may come after 1 hour or sometimes even late also. So by the time, if we had referred the patient, there is an unnecessary trouble for the police in spite of their workload. And that will be shown to us at some point or other. So I will give an example for that. That was the third example. Details of the hospital. And once you give that information, acknowledgement has been received from the station with name of the person receiving the copy, date and time of receiving. So as said, inform the police station when the patient is referred or discharged. Death of the patient, unnatural causes. Inform the patient, keep the body in mortuary, body to be handed over to the police with proper acknowledgement. See, till post-mortem, the body is under the custody of the police and we have to get a proper acknowledgement that they had received the body. Do a post-mortem. After the post-mortem, we are supposed to hand over the body to the police again with a proper acknowledgement stating that we had received the body. So anything in with regard to police, That's common to anything, but with regard to police, always document it and never tell orally, give that in writing. So MLC report is a document which is confidential. Accused is not entitled for the copy of the report, but in general, in practice, most of the time, once we register a medical legal case, both the accused side, opposite side, police, everyone get a report from us. Actually, it has not to be disclosed. And if you are going to give, you have to get an NOC from the police before giving a copy of the report. So, dying declaration. So this was touched upon. So according to BSA 26, inform the police for recording the evidence in front of the magistrate, if unavailable, in the presence of a doctor of the unit or with another gazetted officer or two nursing persons or some other qualified persons in the hospital. So you can do an audio visual recording. So, as per BNSS, interaction between police and practitioner in examination for evidence, examination of person accused of rape, examination after arrest. So section 51 deals with to obtain evidence of the alleged crime, to gather crucial investigation for investigations and trial. BNSS 52, examination of individuals accused of rape or attempted rape. The examination includes, but not limited to, checking for injuries, collecting DNA samples. So, rights of an arrested person. So, arrested person must be examined by medical officer after arrest. Officer must record injuries on the person brought by the police, and details like time of the examination and mentioning of the injuries has to be done mandatorily. Copy of the report of examination must be given to the arrested person or person nominated by the arrested person. Earlier, there was a need for examination every 48 hours. Now that clause has to be taken off. So, the examination has to be done by a medical officer of the central or state government. If not available, made by a registered medical practitioner. For a female, it should be by a female medical officer. The role of medical officer in legal cases, expert witness, evidence of fact, assisting in court to understand complex medical issues and make informed decisions. And it is an corroborative evidence only. So regarding expert witness, I'm telling the last scenario. So once there was an summon issued, summon issued by court, because when police has come stating that you had seen a patient before 10 years. So when you are working in a chair government hospital and you are supposed to come on a particular date to the court for giving witness. So the usual routine is the police will give it that to the higher authority, means the medical officer in charge of the hospital, and the document after signing by him goes to the MRD department and they get the copy of the case sheet and then they will hand over it to us. Here, like it was bypassed and it came directly to me. I told like, see, I need the case sheet. So get the copy signed from the medical officer and bring it so that it will be easier for me to come and give the evidence because it was long back. So after 2 days, so there was no mention. And after 2 days, when I was out of station, the same woman, police woman, came to my house, told that there is an warrant. So because you had not accepted the letter for giving the expert witness. Usually like after 2 or 3 things only that will be given. Here what happened, that female, instead of telling that the protocol, the procedure was not followed, that as requested by me, she told, it seems she told that Doctor was not ready to give the witness. So judge told, give a summon. So on the day when I went there, so as a gazetted officer, then I had to give an explanation on a 20 rupees bond paper and then pray for giving the expert witness on the same date. So these are the troubles what they can make you. So what we have to do is whatever explanation, whatever difficulties you are conveying them, give that in an writing and get a acknowledgement from them stating whatever you had written. So that will be helpful for you. We had seen medical evidence is usually opinion evidence. There are various alterations in that. So it does not prove or disprove prosecution case. So this is mandatory reporting, protection of child from Sexual Offence Act 2012, an act to protect child from offences of sexual assault, harassment and pornography, POSCO acting and mandatory reporting according to sections 19 to 20. You have to provide information to special juvenile police or local police. Last slide, another 2 slides. So it can also be given via District Child Protection Unit, Child Welfare Committee, POSCO e-box, Childline India, National Commission for Protection of Child Rights. So this was dealt earlier, arrest of doctor. A doctor cannot be arrested in a routine manner unless his arrest is necessary for furthering the investigation. That is, unless the investigation officer feels satisfied that the doctor would not make himself available to face the investigation. So there are NMC guidelines, but it's not adapted and lacks legal tenability. So if false FIR is registered, section 520 of 528 of BNSS helps us. High Court can quash FIR if false charges were framed in alleged medical negligence cases. There are some judgments like Daljit Singh case, Jayashree Ingol case. So BNSS section 211 allows to counterfile case against the police for charging false charges. Thank you.
Now, it is open for any questions from audience. Anybody? Yes.
Yeah, so we are aware that if a minor comes with pregnancy, we are supposed to inform the police, right? Now, I have a woman here who is 19-year-old who walks into my clinic with 5 months pregnancy and has a 2-year-old kid. Am I bound to inform the police?
Yes, madam.
Yeah. So it is mandatory, even though it was 2 years ago, that I have to inform the police.
Yes, whether the case is going to stand in the court or not, it's mandatory for us to report that when you suspect that there is a crime which has happened and when you have evidence. Because when somebody else is going to complain and during the process of investigation, they are going to know that you had already investigated. So then you will be in trouble.
Okay, thank you.
It was a wonderful talk, sir. I'm Dr. Shruti. I'm Associate Professor in Obstetrics and Gynecology. So we are seeing POXO cases here, and it is like most of the cases will be the incident would have happened either 3 or 4 months before. But still we get the requisition from the police that we need to send the clothes for examination. Okay, so the clothes which now when we are seeing, they won't be of the incident happened date, but still they ask for the clothes.
So it is like evidence of ongoing activity, these kind of things.
Yes, but does that
See, that's what I'm saying. There are certain things like they have absolute power. We have to accept that. So first thing is they have absolute power. See, like a previous speaker has told, nowadays the compensation, they are giving more than the price sought by the complaint. So let us not get into the details. When they are asking that, get a consent, tell them that as directed by the court, you are supposed to do that.
Okay.
When there is a direction given by them.
No, but those clothes which the used clothes, even if they are available, like the police should recover them, right?
No, the point is like we have to inform. Our role gets over there. And whatever recovery and other things has to be made, the police, along with an accompanying female, they have to come and do the things. It's not our job to go and collect it
No,
and then do it. Apart from while during examination, it's our job.
Yes, sir. Yeah, that's what. But right now, what we will be examining will have no evidence as such. But still, we will be sending and adding the burden to the officer.
Yes.
Thank you.
So regarding the other question which Madam asked, there is one landmark judgment by regarding mandatory reporting. There's a doctor from Kerala. So when she was delivering an girl who was around 18 years, and the case was filed against her for not informing the POSCO authorities. So it's better to inform.
Sir, this is Dr. Rajesh, sir, regarding POXO only. If a case comes with the intimation from the police asking for examination, if most of the times the girl will be minor, if she has not given consent.
We had already seen, sir, there you don't need a consent.
Yeah, even though if no consent, we can
yes, sir,
proceed.
Yes, sir. Medical legal case with someone from the court or from as per the court advice or as per the act, we don't need an consent.
What about examination of
By
a POXO case by a male obstetrician?
So it's as mentioned, it should be by a female medical officer. That's
Thank you, sir.
mandatory.
Thank you.
Mr. Kumar, Dr. Kumar, there is what about the medical legal reports and postmortem reports, whether it is disclosable to the court of law or to the private party victim?
Postmortem, we are going to report it to the court only, sir.
Court of law.
Yes, sir.
Some of the parties, they are seeking information.
No, sir.
Under
Here,
RTA.
most of the time, what happens after a postmortem, we'll be taking viscera or we'll be taking some samples. So it will be like gastric lava, these kind of things. We are ascertaining that so-and-so is dead and the time of death is before this or 8 to 12 hours before postmortem. That we can ascertain. But cause of death is pending this pending viscera and other samples retrieved.
What about MLC records?
Which one, sir?
MLC records.
ML
Medical legal.
Yeah, MLC record, like we are not supposed to give that. We had seen 3 things. So we are not, unless the NOC is given by the police, we are not supposed to give it.
Yes.
But most of the time what happens, we will be giving that wound certificate. It's minor things like assault and other things. We'll be giving a wound certificate to either side.
So some of the advocates on behalf of the accused or victim, they seek information under RTA. So you're not supposed to
Yeah, we are
disclose
not
it.
supposed to.
They are not supposed to
Yes.
disclose it. And,
That's why I specifically mentioned that in the presentation.
yeah, yeah. So it is not disclosable,
Yes.
isn't it?
Yes.
Okay.
Congratulations, Dr. Senthil Kumar, for your informative talk. One practical question as already asked. A minor girl aged about 17 years, married, and she became pregnant, came for delivery before 18 years, 17 years, 9 months. What procedure? Whether they have to do delivery or inform the...
So that's what I said, sir. We have to do the delivery and the treatment as such. First aid treatment is more important.
Yes.
But we have to inform the police. In case if the patient escapes after treatment also, we have to inform the police with whatever knowledge we have.
Legally married. Legally and...
Yeah, but once POSCO came, that legal
yes.
marriage
That
doesn't
will
exist
not-
before
yes.
18 years.
Yes, before
Court,
18 years.
different times they have a different views onto that. Most of them were like left alone.
Not legal.
Even some courts have observed that there is an overreach, judicial overreach on that. This law, there are some discussions like that, like you said, there is no legal thing before the age of 18. But sometimes courts, I know few cases where they were acquitted.
But delivery can be done, but should be informed.
It has to be, sir.
Okay. Thank you.
Thank you.
Thank you,
Question-
sir.
Hello, excuse me. Question to Vivek Durai. In Karnataka, is that does the POSCO is applicable only for Hindus or to other communities also?
Thank
Across all communities, sir.
Thank you, Dr. Senthil Kumar.
Thank
Very nice. Thank you very much.
It is across 7.5 crore people, sir. Thank you. Not only for Hindus, Muslims, Christians,
sir.
Buddhists,
I
everyone.
request the chairpersons
Yes.
to kindly give the memento to
No, no, no.
Dr.
No,
Senthil
sir.
Kumar, sir.
Okay, thank you.
I request the next speaker, Dr. Doreraj, Advocate Doreraj, sir, to kindly come up on the stage. The topic will be received a legal notice, what to do next.
Dr. Yes, next speaker, Dr. Doreraj, introduction. Dr. Doreraju, practice areas advocate. Is Advocate Doreraju, practice areas litigation, education LLB, National University of Juridical Sciences, Kolkata. Litigation and dispute resolution. His expertise lies in litigation, appearing before various high courts, commercial courts, civil court, NCLT, KERC, and DRT. Dorai is a legal assessor to Karnataka Medical Council and is also standing counsel for the central government institution like FSSAI and NHAI, for the state government institutions like KSFC, KIADB, KSSIDC. Dorai has studied in World Trade Institute, Bern, in relation to international trade. Welcome. And now I presenting Dr. Dorai Raju for its
Thanks,
session.
Thanks for short introduction. So from the slide and the topic that is given to me is because I am advocate, they called me to answer what is your advice on how to take on when you receive a legal notice. So before going to that, broadly, I will give to all the professionals who are here to understand the judicial mechanism which is right now available in India when it comes to medical negligence cases. Broadly imagine the judicial mechanism in adjudicating your medical negligence. Firstly, when a medical negligence case is coming, when there is a complaint, there are three forums which will come to mind. One is there is criminal negligence, then there is domestic inquiry, then there is consumer protection. So we are at the threshold of understanding how to tackle notice. So I'll give you a irony of the judiciary now, which is dealing the medical education, medical negligence matters. A case goes to medical negligence in a medical council. You can fairly imagine the time consumption there for an experts to form an opinion. While parallelly, there will be a police complaint where there will be a trial going on. While also for a compensatory relief, the victim will again go to consumer forum. So in one point of time, at one cause of action, there will be three proceedings which will be going on. So, but here we are still worrying at what to do when you receive a legal notice. The moment you receive a legal notice, you be prepared for three forums. Invariably, you will go for domestic inquiry. Invariably, you will go before consumer protection forum. Invariably, it will go before a magistrate under 304A, medical negligence, IPC. So with this broad spectrum of judicial mechanism, and you can imagine the time consumption, and from there appeals. challenging at each forum. Only when it gets convicted or sentence is passed at the medical council, then the bearings will start at consumer forum, or rather even at the magistrate level. Because none of these forums are expert in the subject to give any opinion on the medical negligence matter. So invariably it is Karnataka Medical Council, which is a domestic inquiry, which is going to kickstart the medical negligence case from the notice. So what is notice? So for a moment, imagine there is a case, something related to a violation with respect to medical ethics code, or even for that matter, when it comes to billing, infrastructural issues. So there are two forums invariably. One, you may get it at KPME, other one is Karnataka Medical Council. So the victim not necessarily will issue a legal notice, because legal notice is not a statutory requirement for you to file any of these cases. The moment there is an apprehension of or a misunderstanding of a medical negligence issue, there is no requirement of a notice. So the proceedings have already started even before you coming to know there is a medical negligence case has been initiated against you through a legal notice. So don't be under the impression that unless you get a notice, they cannot initiate any legal proceedings against you. So let's assume for a moment somebody is following a due process of law and sent a notice. So what notice they would send? Under what laws? So when faced with the legal notice, what to be done, do's and don'ts, and practical considerations. These are the 4 segments that I will talk when you probably receive a notice. So what is a legal notice? A legal notice is a formal written communication between parties. So please, as I already given a caveat, nowhere here it says it's a mandatory requirement under any provisions of law. So helps in making a receiving party aware of grievance of the sender. It's just a warning you're going to get. Oh, this is where you have gone wrong. And this is where I will, call you for challenge. States the dispute that the sender has against the recipient. Broadly outlining, they will not give you the insight of the question that they are raising, the insight of the allegation, they will not. Broadly, they will give, I was your patient and there is a medical negligence. Includes the relief sought by the sender. Not necessarily this inclusion of relief has to be there in a medical notice, which when they send a medical notice, legal notice. Notifies the recipient through the legal notice about the sender's intention of undertaking a legal proceedings against the recipient. Meaning to say, in the broad sense, that he will not disclose what is the dispute. He will not disclose necessarily under law what relief he is going to claim. He is going to just make a bold allegation. There is a medical negligence case I'm going to file against you during the course of the treatment. That's all they will going to say. So the laws and the issues impacting medical profession. So this part, I've gone little out of context just to bring the broad spectrum of all the medical laws that one has to be aware during the profession. I'm sure these are the laws which are probably dealt during their college days as a 1 class or 2 class where they will brief you what are the laws, what is where you're going to do registration, what are the kind of laws that are there for your protection rather than for your defense, or rather for what are the laws available for victims against you. They will not teach you in that perspective. They will teach you in the perspective of what are the laws available for your protection during your profession. So in that perspective, there is one definition which is lacking in the medical negligence. The notice that we spoke will not tell about what is medical negligence, will not disclose about what is his allegation, will not disclose about what is the relief he wants, but he will only tell, I'm going to file a medical negligence case against you. So now the next question that we want to understand is, what is medical negligence as it defined? So the medical negligence per se is not defined by any law. So it is there in our ethics code. So what all will come under that medical negligence is comprehensively but exhaustive. It is not fully exhaustive. There is an element of inclusiveness. Each and every aspect can be called as a medical negligence. Now under section 304A of IPC, negligence is defined. Gross negligence is defined, not the medical negligence. So medical negligence is an act or an omission by a healthcare provider which deviates from accepted standard of practice in the medical community, which causes injury to the patient. The foremost thing in a medical negligence case is it should cause injury. If there is no injury, then it is not a medical negligence case, is what they have understood. But there is a recent case law which is from Supreme Court. There is not necessarily there should be a damage for medical negligence case. Because again, it goes back to what is called as discovery rule, which I will explain in my during the course of this talk at the last part. So there are various kinds of situations which amounts to medical negligence by medical professionals such as incorrect diagnosis, deferred diagnosis, inaccurate surgery, long-term negligent treatment, childbirth and labor malpractice, needless surgery, erroneous administration of anesthesia, etc. So with this broad, still not exhaustive, the medical negligence definition is even today, as per Supreme Court, is still inclusive. So they're going to keep adding what all can be medical negligence. So now the next question is, when there is a medical negligence, what are the kind of liabilities which will come up? So there are the three liabilities that I've already said, the three forums. Squaring is criminal liability under various provisions of Indian Penal Code. Now I'll mark it what is various provisions. There is one provision which is relevant for medical negligence is 304A. Any person who acts negligently, rashly, that results threat to human life or personal safety or result in death of a person, then the person shall be punished with imprisonment and fine. With this criminal liability, can you fit where the medical negligence can come into this definition of criminal liability? Look at the definition which is required under negligence for under IPC. Is results in death, threat to human life, personal safety. These are the three end results which are there in negligent act. So for a medical negligent, it has to be within the parameters of medical treatment. So where the negligent and rashly, your action of negligent and rashly omission couples to human life, threat to human life, personal safety, and results of a death. So only in these parlance, IPC is section 304A is interpreted to what is called as medical negligence for criminal liability. Now with the same understanding, what will become a civil liability? Civil liability, when I say the person cannot go and file a suit in a civil court. So under medical laws, the person who is coming to you is being considered and treated as a consumer now, because what you're providing is a service. Though you are doing a noble act, but at the end of the day, there's a commercial transaction between you and the patient. For a consideration, the service is provided. So what comes, the next case, the next situation is a consumer element. There is a person who is consuming your service becomes a consumer. Now, what is a consumer liability? Any aggrieved person who comes to you for a treatment, any aggrieved person can approach a consumer court to file a case against an accused person and the hospital. Here, I've used the definition of criminal liability to make a stress on accused. When the accused word is used, don't misunderstand. There is already a criminal sense of it. Accused is not in the criminal parlance. It is the English connotation of the word just is used as the one person is accusing me of something. Now, disciplinary action, the third part, that is where the domestic inquiry happens for a doctor. Now, the doctors, after their graduations, they all register at Karnataka Medical Council and KMR Act, Karnataka Medical Registration Act. Now, after registration, it is the council which regulates your practice per se. And I will not say at what are the standards they have asked you to maintain, but it is the regulation which is there. Medical ethics code is a regulation which is required to be maintained by a professional, a doctor, for medical practice. Now, deviating from that medical ethics code will call in question at the Karnataka Medical Council. Now, there is an element of medical negligence in a criminal sense vis-a-vis the domestic inquiry. Now, I'll give you what we are facing at Karnataka Medical Council for me being under the circumstances of holding a post of a legal assessor. Now, invariably, what is happening? There are complaints which are filed at police station. Now, probably that part will be covered by the next speaker, how it will be. But I'll just give briefly. There is a police complaint. And somebody files a police complaint. As per Supreme Court judgment, Jacob Matthews case, how the police should deal with the complaint. Whether they can immediately register a police complaint to an FIR. No, they cannot. As per that directives of the Supreme Court judgment, Jacob Matthews, there has to be a board formed. A lot of confusions were there in the police department. What is this board? Because the boards are not defined by law. So invariably it was sent to Karnataka Medical Council for an opinion. Now, Karnataka Medical Council holds an inquiry proceedings. Though they are the expert bodies who are sitting, they do inquiry proceedings on the basis of a complaint and not on the basis of a police seeking an opinion. There's a difference. In an inquiry proceedings, there has to be a complaint, not somebody seeking an opinion. So with that differentiation in the inquiry proceedings, Karnataka Medical Council deals the actions of the professional medical doctor if he is deviating from the ethics code. That is where the domestic inquiry kickstarts at Karnataka Medical Council. Now, I did not speak about the last leg of that definition of disciplinary action is what will Karnataka Medical Council do with the findings if they come to a conclusion that there is a medical negligence proven. So the inquiry proceedings finally results in the deletion of the name from the registrar. That will be published in a Gazette notification and all other practicing places of areas where people will come to know that a disciplinary action has been made against you and you have been removed from the register where you cannot practice. So these are the other laws which I have, put across where in your profession it may be relevant because of safe storage drugs. There are regulations how the drugs are kept. So one of those pieces of legislation I've just put forth here, vicarious liability and Indian tort. Now, to give another example, the doctor is not very far from an institution in today's days of practice. Invariably, unlike in the rural areas, the doctors are attached to institutions, and these institutions are attained either in the form of a company or a trust or a society or an association. So a doctor who practices, who is a physician, when he's practicing, when he's attached to an hospital or an institution, so what is the law which comes in play, interplay for a medical negligence of a doctor and when he's attached to an institution? When he's attached to an institution and this institution cannot be registered without the presence of a doctor, invariably the doctor has to be there for you to open an establishment under KPME. Now, the relationship between a doctor and the company for which he is working, there is an element of corporate will in it, what is called as profit oriented. You may say the hospitals are not profit oriented for argument's sake, but what is the law states is something called vicarious liability. The vicarious liability concept is the employee is responsible for his actions of the agent. Now, who is the agent and who is the employee here? The employee is the company, the institution, the establishment. The hospital is your employee, and you, part of that institution, whether you may define your contract, you're just a consultant, visiting faculty, visiting consultant, whatever be, but you'll remain an agent to an employee where vicarious liability will kick in the civil liability. So when faced with the legal notice do's and don'ts, with the three forums I've already explained what cautionary measures that you have to take or not take is the one bit I have identified. Identification of issues when you get a legal notice. So you need to map what are the issues raised in the allegations made. Legal issue, whether about your treatment or whether about infrastructure. So it was a treatment and was all the treatment and the process of the treatment under your control, then you map that. Or if it is related to an infrastructure, then the issue will become KPME issue, where the complaints will go before inquiry, judicial examination, inquiry examination under KPME. So legal representation. Now this is where a lot of discrepancies we are seeing at medical council. That is legal representation. When you are having a contract with an institution, to what extent you can appear and represent the establishment that you're working will already be defined. What is your liability? How much it is restricted? The freedom which is granted in that employment agreement, what you can disclose, whether your treatment records, case sheet, whether it's your property, whether it's the property of a hospital. So all these issues will come up when you are attached to an institution and which is an institution registered. So these are the elements which will be there. During that time, who is the right representative of a hospital? Can a person merely having a managerial skills, not being a doctor, can he represent a medical establishment and come and answer medical questions? Questions related to treatment? A person who is in a managerial role, will he understand the medical equipments? I'm not talking about the mechanical aspects of the medical equipment here. On the medical equipment, how it functions to a treatment, can a manager who is not having a medical field, understanding of a medical field and not being a doctor, can he represent a medical establishment? Can he represent a doctor? then obviously after you receiving a reply, you will, but of course, issue a reply notice. And my only observation while you issue a reply notice to keep things vague, leave it to adjudication. That was my caveat. And bail is the one last aspect, because there is no much criminal element in the medical negligence and there can no be arrest. So bail is an optional to take anticipatory bail. That's all. Lastly, what do you do when you receive a legal notice? Admission of claims. We should not make any admission to the claims. Then definitely no destruction of evidence, medical records, rewriting, covering the pages, destruction, all of that, creation of new records, and unduly influencing the parties. Let's go for settlement. So please avoid all of this. The practical consideration, I don't have to give much about what practical consideration requires for a medical professional as a doctor. What medical professionals do. Insurance has become a norm in your practice today. Now, the defamation is something we have recently been seeing. A lot of cases have been filed by doctors against those who indulge in defaming. A lot of doctors' practice and reputation is in the social media, on the websites, on the domains, and all of these places. So what kind of repercussion is there when somebody talks very loosely about your work, your actions? So there is an element of defamation. A lot of people misunderstood. Insult is said not necessarily in front of others. It can be between individuals. One can insult you without the presence of anybody. But the element of public devastating is required in your defamation. So IPC for insult and defamation is different. Lastly, thank you for giving me this opportunity for this IMA, for hosting this conference and giving me an invitation to speak on it. Remember this, it will be of some help. Thank you.
Thank you, Dr. Dharar as advocate, sir, for your excellent presentation and most informative talk about the medical negligence and criminal liability and regulations of the KMC, Karnataka Medical Council. The subject is open for discussion. Any queries? Can
thank you.
For the short up time, they can ask 1 or 2 questions only.
Thank you, Advocate Vivek, for the excellent presentation. I have 2 observations. Since for the last 15-20 years, I am into the medical legal issues of our medical professionals. 304A, now amended from July 1st of 2024, BNS 116. They're all bailable. Okay. When you have a bailable option, 304A or 116, I don't think there's a need to go for anticipatory bail.
Absolutely.
I had this thing last year. Okay, one dentist was there and police was inquired him under 304A before BNS came into action, and he was harassed too much. Advocates expected the lakhs of rupees for him to get the anticipatory bail. Ultimately, what they did nothing. They just collected money. Then I came there. I said, I requested the advocate, he is the bailable. His wife or his friend or me can get a sign in the police station and relieve him. Then why did you go for anticipatory? He had no answer. Ultimately, I could see to that 2 cases are squashed in the High Court of Dharwad bench just for falsely putting the FIR on a dentist. True. So the other observation is, when the doctor is working in a hospital may not become an employee. He is an employer. Okay, the one who is working in that hospital, okay, we become the employee and the onus falls on the employer, that is institutional. That is also vicariously liable, but not the employee and the employer both will become the parties for that particular case. Yeah, these are my observations.
Yes, sir. So in the vicarious liability, I did not say the agent gets absolved of the liability. invariably the liability remains on the treating doctor,
Yeah.
but the doctor who is attached to an institution,
Yeah.
a company, a charitable trust, they have to own the responsibility for the treatment because you're employed.
Yes.
And an element of profit is there.
Yeah.
So for that purpose, vicarious liability of a tort is brought in the Consumer Protection Act, and even for domestic inquiries that we are looking into.
Yeah.
Now, the bail part that I was briefing is, today we know because of a lot of exposures that is there, and how the police was exploiting the circumstances of calling the doctor a professional, the medical professional, to investigations. Today, from the Karnataka Medical Council, a lot of endeavors have been made, met the directors of the police department agency, investigative agency, that you don't summon a doctor.
Yeah.
You don't call them. At the investigation level, you will seek only the documentation. And based on that documentation, you're sending it for a medical board expert opinion for you to register an FIR. So without there being an FIR, obviously they cannot arrest you. So the offense is not yet committed. They have not even formed an opinion. So with that, the bail option, what we were stating from the older perspective of how the law has expanded today, and there is no requirement of per se bail. Anticipatory bail is in the colloquial nature of seeing things. Be anticipated that when there is an issue of medical negligence, police will walk onto your institution or your establishment seeking documents. For that purpose, you don't need bail, sir.
Yeah. The extension of one more sentence. Recently, the advocate told the doctor, you run away for a week because you have to get anticipated because Friday, Saturday. Then it was at 116, and we went to intervene and immediately got the bail. There was no necessity for him to run away from the city for a week or so. Thank you.
There is one question from online delegate. The question is, if the doctor has gone for a field duty at a PHC, a case of accident comes and nurse does the dressing, and the patient is bleeding. So she takes care of the patient. By the time the doctor comes back, the patient has left. And now the patients are demanding the wound certificate. So what has to be done in such
Yes, sir.
situation?
This was a peculiar situation we had come across in our medical council when we were looking into one issue. A doctor has treated a patient, given a prescription, and the patient goes to the medical shop, gets the drug, and comes to the same doctor to get a confirmation whether this is the prescription, this is the right medicine. Invariably, this happens. At that point of time, the doctor has said, yes, this is a drug. But when he goes back, whether he has used the same drug, whether the pharmacy has given the same drug. So the pharmacy council came into issue. What was prescribed to what was taken and what was confirmed by the doctor also, different drugs. Now, that patient took the drug, went to a hospital. The physician said, dekh lo. The nurse saw, gave the injection, baby died.
So the question is, in the absence of the doctor,
Now,
patient has,
when the absence of a doctor, whether nurse in a medical establishment working independently,
she is not.
So there are limitations made to what extent she can make a judgment. She can form an opinion. Did she deviate from making that opinion? Did she form an opinion without a consultation of a doctor? Now that element will go to nursing council if there is any inquiry proceedings, whether she acted fairly. No, but obvious here for seeking medical certificate for wound certificate cannot be given because the physician is not treated. Thank you.
Thank you. Thank you
I
very
have a
much for the
question.
informative talk. Thank you, sir.
Regarding negligence definition, there is standard of procedure.
Sir,
Durai sir, a question for you.
Sorry.
According to definition of negligence, if there is a deviation of standard of procedure, it's called negligence. But we don't have standard of procedure in India. Unlike GMC UK, they have SOPs. But in India, we don't have any SOPs. How to define negligence in such a case?
Sir, now, this.
Hello. Yeah, if I could answer this in an Indian scenario,
Please, sir.
It is defined as what a common medical graduate would have done in that given situation. That is what they define in India. Whereas in, as sir said, in GMC or AMC for that matter, Australian Medical Council or General Medical Council, they have standard treatment protocols for everybody, including what you said recently, nurses. A nurse in an emergency department, there is a nurse to put only IV cannula.
Correct.
There is a nurse to do only ECG.
Right.
They don't interchange. Whereas in Indian standards, a nurse, they do everything. A male nurse will drive the ambulance, a male nurse will take an X-ray, a male nurse will do everything. Sometimes even in intubation also. So that doesn't happen there because there is a standard treatment protocol for all the procedures.
Sir, with the question that you pose, that is being so vague about medical negligence, I will give you a new scenario of the new laws of central government, which is permitting BNS graduates to be employed in medical establishments. How will you treat that? When they do negligence, where will you put them? I will give you one more example. The NIMANS recently has given Ayurveda medicines.
Due to shortage of time, we'll conclude the
Thank you.
session.
Thank you,
Hello.
sir.
Please
Thank you,
stand.
Advocate
Sir,
Doriraj.
one point.
Yes.
Answer to Pawan's this thing. There is definite standard treatment guidelines by the central government. It is there in the Central Establishment Act site. Kindly go through. Specialty wise, they have given it. That is the standard treatment protocol. I mean guidelines that can be quoted in any of the court of law.
Sir,
Thank you, Madhusudan, sir.
Thank you so much.
Thank you, Doriraj, sir. I request the chairpersons to kindly give the memento to Advocate Doriraj, sir. Any more questions from the delegates? They can directly approach the speakers. Now I call upon Advocate Dr. Jogarao, sir, from Legal Excel Attorneys, Bangalore, to kindly talk about Bolam's and Bolito test. Over to you,
Professor
Chairperson.
Dr. S.V. Jogarao. He is presently anchoring the professional activities of Legal Excel Attorneys, a law firm of advocates.
Simple. 1 or 2 lines.
Yeah. He is a founding faculty member of Law University, Bangalore, since 1988, teaching experience of more than 3 decades. He has founded Legal Action 2001, working as a law firm, healthcare law consultation in Bangalore. With this brief introduction, now I call upon Dr. Jogarao to present his presentation regarding 2 important tests, that is Bolam test and Bolito test. Thank you, sir.
Thank you, doctors. Am I audible, friends? IMA State and Gadag branch, particularly Dr. Pawan Kumar Patil, I want to thank him because he personally asked me to address on this topic. As you are aware, in the context of medical law and ethics, the kind of academic research, writing, and debates that revolve around Bolam and other judicial precedents, more of academic character, not necessarily for a seminar presentation. But when he requested me, I thought I should make an attempt. That's why I'm really thankful to him. And more particularly, the concluding question that was asked, where a couple of members of Honorable KMC, they have responded to. I think that's a very important question, which I'm going to take it from them. Many people think Bolam ends with Bolito. No, that's not correct. That is the reason why Bolam, Bolito, and beyond, much water has flown from Bolito. It has reached a stage where, in fact, if you ask any researcher of common law based, you will find maximum literature on this topic in almost all common law countries. For the purpose of this presentation, I have specifically selected some sources. Next. These articles provide a great deal of insight about the issue. First one to begin with, Michael Kirby, Justice from Sydney, Australia. Then comes Professor Andrew Grubb, one of the renowned professors of medical law in UK, followed by Margaret Brazier from University of Manchester. And finally, from a very recent article where it is published in Indonesian Comparative Law Review. There are many more, but I felt these four give the insight which I propose to share with you. Recently, I was invited to a book launch function for a panel discussion. The book title is Passive Patienthood, Disrespect in Law and Medicine, written by Supriya Subramani, who has completed her PhD from School of Humanities, IIT Madras. Now she is working in School of Public Health, Sydney. She invited me along with others. In fact, in the panel discussion, our own Professor Sundar Sarukai, he was present. And from Mumbai, Amar Jesani was present. The book, in fact, I knew her very well for the last 12, 13 years. She was in consultation with me, whatever assistance we are rendering. The way the scholarly outcome of the book is something amazing for me. There are three factors. Our paternalism leads to passivity in patient. That's the theme. I repeat once again. Power, paternalism leads to passivity in patients. It is a critical philosophical ethnography study, almost 300 odd pages. Her main critique is about the informed consent. Why am I mentioning about this particular source? In India, I have not come across a study which really looks into the roots of the problem. Now, why do we need to discuss about Bolam? Bolito. Why? My dear friends, the question that was concluded recently, asked, how do you adjudicate whether a particular conduct is negligent or not? As you all aware, duty of care, breach of such duty, and injury on account of such breach is what is the legal principle. Care we can identify in terms of the contract, relationship, sovereign function, etc. Injury we can make out in terms of what happened to the patient. But how do you decide breach of duty? Particularly in the light of where the standard practices or procedures are not only standardized, but they are not documented. In such a case, what is the way out? Today's morning presentation Dr. Ramesh Badamath. He did refer to Bolam and Bolito. Let me explain to you. In the year 1957, in UK context, there was nothing available as a matter of yardstick to decide whether a doctor's service is negligent or not. At that point of time, the Bolam test became one of the most important tests to decide. How do you decide? Very simple. If my conduct is in question, whatever service I have done, it will be seen by my own peers or colleagues of the same locality, same context. If any one of them says, yes, this is what we also follow, in such a case, the doctor is not negligent. That's called Bolam, which means mostly whether the doctor is negligent or not is decided in the light of the fraternity finding or opinion and accord. Was there a critique for this? My dear friends, till Bolito came, a lot of critique, particularly from academic writings. Professor Andrew Grubb, one of the most vocalist against Bolam. Many people said, you are allowing doctors to say that they are not negligent, and courts are abdicating their responsibility in deciding whether doctors are negligent or not. Because whenever a doctor's expert opinion is given, the doctor says, this is what generally it is being done. Therefore, on that basis, the doctor is held not guilty or not negligent. Though Bolam ruled for 40 years, my dear friends, Bolito has shaken up the foundation of Bolam. Simple, very simple. I mean, I know the judgment is very, very complex, runs into many pages. The simple question what Lord Wilkinson said is, the very aura of Bolam must be revisited. It is not that the expert opinion is only taken into consideration and the judge says the doctor is not negligent. No, that's not the job. The real test is whatever the opinion that is given by the expert doctor, is that reliable? That is what the judge is going to decide. Simply because a doctor gave an opinion evidence does not mean the doctor is not negligent. The opinion evidence that is given by the doctor needs to be scrutinized. There must be a logical basis for it. That is how the foundation has been shaken. But many people think in English history, Bolito is the final. No. Post Bolito, several judgments came, particularly Sidaway. Sidaway, Board of Governors, Bethlehem. My dear friends, many of us, we tend to think that Bolam test is only with regard to adjudicating breach of duty, whether the doctor has failed to take exercise or care. That's it. But you are mistaken. The premise of Bolam has been expanded in Sidaway. They said it is not only for breach of duty, even for informed consent, you have to follow Bolam. That is the reason why the expansive nature of Bolam came into in Sidaway, but in Montgomery, the next case that is recent to 2015, the English courts gave a very, very landmark judgment by saying not only Bolam must be avoided, even Sidaway must be avoided, because when we talk about either breach of duty or informed consent, the focus ought to be the patient for whom or with whom you are interacting. It is not what you think. It is what patient needs. And accordingly, there is a lot of change that has come about. That's where the English position has taken that. Please remember, the English experience is not merely limited to UK context. one of the very important country which really took the base is Australia. Rogers versus Whitaker, 1992, where they dumped Bolam and they said, no, it cannot be. It cannot be that the doctor will decide what needs to be done, or a doctor's opinion will be taken and judges will surrender to doctor's opinion. No. Therefore, Rogers versus Whitaker, the Australian court came out very clearly by saying it must be patient-centered focus. And accordingly, what kind of information that is required to be given, either in the informed consent or of the standard of care, the patient is the focus, but it is not what doctors think. This influence has reached even in our own South Asian country. Malaysia, the Federal Court of Malaysia has recently, 5 years back, said Bolam is no longer the valid test. Where do we stand? India. My dear friends, lot of turbulence we have experienced. But when it comes to Indian context, personally, I tried to understand what are the reasons, but I could not. In India, Honorable Supreme Court time and again reiterated affirmatively that Bolam is the test to be followed. There are other developments which they acknowledge. The Honorable Supreme Court writes in the judgment that there are other developments in countries like X, Y, Z. But in our country, considering our own sociological, economic conditions, etc., Bolam test must be followed. Therefore, naturally, we have followed Bolam test because that's where the breach of duty you will be able to evaluate. But please remember, it is not merely breach of duty, but it also extends to informed consent. That's where one of the scholarly judgments of Justice R.V. Ravindran, 2008, I think, Samira Kohli versus Dr. Prabha Manchandana, where Honorable Justice Ravindran very clearly mentioned he goes with Bolam because the other extreme opposite is American perspective, which in a way got reflected in Rogers Montgomery. That is called Canterbury. He refers to Bolam and Canterbury, and he says, Canterbury I am not preferring because we have our own sociological conditions, so many factors, etc. But having said, as matters stand, Bolam. My dear friends, personally, I do not endorse that view. I have written, I have mentioned, for me, the social reality demands accountability must be objective and fair. Whoever it is, whichever discipline. Therefore, I, for one, would not endorse Bolam. I think we need to take note of where the court doesn't abdicate its responsibility, but court decides whether the doctor is right or wrong, not only on the basis of expert opinion evidence. Finally, when it comes to informed consent, I must tell you, Justice Ravindran, particularly in 2 or 3 paragraphs, no doubt he endorses paternalism. He endorses. But he did say some aspects of the Canterbury he did incorporate. That is the reason why when we talk about informed consent, the adequate information must be shared as a matter of legal duty by the doctor with the patient, so that the patient will be able to take a call whether to undergo the intervention what was advised by the doctor. I think that's the law of the land. Thank you so much. Questions? Oh, pleasure. I hope time.
Any questions from the audience or any clarifications? I think one question is there.
So the days may not be far away that these principles of Rogers versus Whitaker or Montgomery's would come into this land also. So can you elaborate a little on Montgomery's, how much the definition is expanded in their opinion about medical negligence?
Montgomery. Doctor, Montgomery.
Yeah.
Yeah.
Because that's the latest one.
That's right. 2015, House of Lords. Friends, Montgomery, if we really look into the standard, from Bolam, No doubt Sidave expanded, but Sidave confirmed the prudent man's test, what is being followed by a doctor. Montgomery has rejected that. Montgomery says, no, it is not what you think as a doctor. You need to think what is required to be communicated from a patient point of view. It is individual patient dependent argument. That's where Montgomery has brought about the most important question, autonomy in a patient. Friends, in our sociological conditions and our own cultural context, I'm sorry for my observation, please don't mistake me, but this is what is the truth. Many of us, we don't understand philosophical, humanities, other branches, knowledges. Suppose when we say autonomy, very honestly, what exactly is the connotation of autonomy? We don't. It is not only you, the way you are oriented in your medical curriculum with your even law. We are all black letter lawyers. Our input with regard to humanities, etc., very, very minimal. Therefore, Montgomery has stressed very significantly the responsibility of not only in terms of breach of duty, even in terms of informed consent, material risk disclosure. Material, what you think is not material. What you need to understand, the patient may, and accordingly from patient's point of view to do. I must tell you, Honorable Supreme Court took a conscious decision. I'm talking about Canterbury because by then Montgomery has not come. But post-Montgomery developments, we are not sure. For the simple reason, in India, even today, Samira Kohli is the law of the land stands, and there is not even a whisper about any kind of critique or overruling, etc. Therefore, we may have to wait for maybe Montgomery days. Thank you.
Thank you, Dr. Jogarao, for a nice
Thank you so much,
presentation
sir.
and clearing all the doubts of the audience. Thank you.
Thank you.
I request the chairpersons to kindly hand over the memento to Advocate
Sure.
Dr. Jogarao, sir.
A small request to everyone,
Ah.
please not to leave the auditorium. As tea is little bit late by half an
Samira
hour,
Kohli.
we'll have the moot court session the next thing.
Correct.
Thank you.
Yes, thank you so much. Thank you.
So this session
Thank
ends
you.
here.
Thank you so much.
I request
Thank you.
Nurani, sir, to kindly present the
Really?
mementos to the chairpersons. Dr. Bidnal, sir, Dr. Shekhar, sir, Dr. Mantesh, sir, please wait.
You are the person because of
Thank you. Thank you, chairpersons, for conducting this session. So next we're going to have the most awaited part of the conference, moot court. I hope all of you have gone through the cases. It has been shared in the delegate group. If not, I request you to kindly just go through the case, go through the first moot case, so you'll get an idea of what the history is. Then it will become very easy for you to follow the moot court proceedings. It'll take 10 minutes for us to set up the moot court. I would like to announce again that there's a banquet today organized at Utsav Bhavan at 7:30. I would like to read out the disclaimer. The moot court proceeding conducted purely for educational purposes and for creating awareness on courtroom proceedings. There is no intent or attempt made to misinterpret the courtroom proceedings or bring disrepute to the judiciary. In the meanwhile, I would like to introduce the team which is conducting the moot court. It is Dr. Joga Rao's team, Legal Excel Attorneys. It is headed by Professor Dr. S.V. Joga Rao sir, Dr. S. Radha Pyari, S. Yashwant Prasad, who is a senior associate, Arun Kumar, who is an associate, Vemuri Fani, who is a junior associate, Nirmal, junior associate, Kavana, junior associate, G.S. Nagendra, executive admin, Ria, intern, and Mrs. Saujanya Prashanti Ramakumari, who is an HR professional.
What is right? Check one, check, test, hello.
Shall we?
Check, 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 check. 1, 2, 3. Oh, hello. Check. Hello. Yes. Sorry. Hello. Hello.
No. Yes. Hello.
Hello.
You should.
Open court.
There are a total of 3 cases which are up for arguments. And out of 30 cases, so 3 cases we'll be hearing today.
IA number 1 of 2019 in Red Petition 3452 of 2019, Shakahari Hotel versus Mr. A. Counsel for applicant in IA, Advocate S.V. Jogarao. Counsel for respondent in IA, Advocate Arun Kumar.
Your Honor, this particular IA representing the workers' union is filed under Section 17B of Industrial Disputes Act. Earlier, when the labor court ordered reinstatement along with back wages, the hotel obtained a stay from the High Court, and accordingly, we have filed this application for interim compensation. That's the matter.
My lord, therefore the respondent in this matter, we filed our detailed objections to IA. My learned counsel, the application in the matter, no supporting material supporting evidence, and for 17B interim wages. In this matter, these applications may be dismissed.
Your Honor, I'm not sure how my learned colleague made that submission. Under Section 17B, I'm supposed to make a filing along with an affidavit. Yes, and we have filed the affidavit stating that our workmen are not gainfully employed and waiting for the hotel to give the back wages and reinstatement. Therefore, in my opinion, his submission is not valid.
By talking about you, only P of bank statement, these documents, my lord, is not permitted in the honorable court. So maybe application is dismissed.
My
considering the claims made by both the parties, I suggest both of you can have a discussion and negotiate about the possibility of any settlement in this matter.
Your Honor, we are ready to explore settlement. Maybe the date may be given
Yes,
for.
ma'am. I kindly 2 weeks time grant, my lord. I will discuss with my client also.
Kindly.
My
2 weeks
much
for exploring and reporting on settlement.
Yes, much obliged.
Grateful.
Next date of hearing 27/6 for reporting on settlement. MFA 3021 of 2023, Mr. B versus Mr. D. Counsel for petitioner, Advocate S.V. Jogarao, and counsel for respondent, Advocate S. Yashwant Prasad.
Appearing for the respondent in this matter, Your Leadership.
Your Honor, this particular matter pertains to father's claim to have visitation rights. The divorce matter is pending before the family court, and I sought the custody of the child, minor baby girl. Honorable High Court has decided, considering the age of the baby, the custody must go to the mother. With that particular order, again I have approached High Court, asking, praying for the visitation rights. What I noticed is, even though High Court has ordered visitation rights for me, every weekend mother takes the baby to her family kitty parties. Every Sunday, she goes to some temple or the other to do some bhajan or puja. Whenever vacation comes, mother takes the child to her parents' place, which is in Chandigarh. As a result, for the last 2 to 3 years, I could not even see my baby. Therefore, my plea is for a very clear, explicitly provided visitation rights for me.
Your Leadership, yes, Your Leadership. In respect of this particular MFA, I have filed my statement of objections captured in a written submission, and I've also filed a copy, and the same may be perused, wherein I have vehemently objected to the very relief that is being sought by the petitioner. In fact, the objections stem from the concern that I have as a mother towards my daughter, wherein there have been past instances where the father has intimidated the child. And in respect of such conduct towards the child, I'm afraid that he may pursue such intimidating tactics, and that is going to affect the child's mental well-being. And therefore, I vehemently object to passing any sort of relief insofar as the appellant is concerned. And I humbly pray that the MFA may be dismissed with exemplary cause, because the petitioner or the appellant has been dragging me unnecessarily to courts. And therefore, I humbly request that the appeal may be dismissed.
Your Honor, mere utterances castigating, character assassinating the father without any kind of evidence is something to be taken note. There is no shred of evidence indicating, revealing that I have intimidated my child. These are all stories that are built. Your Lordship, there is a necessity for Article 21, Constitution of India recognizes the right to life and personal, even for the child. And as a father, I am entitled. And I make a submission in the light of the recent Supreme Court judgment, the recent 2025 judgment, Supreme Court, wherein the Supreme Court mentioned, if at all there is a concern for safety, insecurity for the mother vis-a-vis baby, a court commissioner can be appointed when the baby is with the father. Therefore, in the light of the judgment, in my opinion, the objections raised by the mother's counsel, they are not applicable. And accordingly, we pray for some kind of relief.
Take this dictation. considering the interests of both parties, having considered the contentions of both the parties, this court is of the opinion that while upholding the custody of mother, the court also considers the rights of the father to build a bond with the child and therefore direct the respondent to allow and facilitate visitation rights of father on every Saturday between 10 a.m. to 5 p.m. and on Sundays between 10 a.m. to 5:30 p.m. And both the parties are directed to comply and respect this order.
Obliged. Much obliged.
Criminal petition number 01 of 2021, Dr. Y versus Mr. L and others. Counsel for Dr. Y petitioner, Advocate S.V. Jogarao. Counsel for Mr. L, respondent number 1, Advocate Yashwant Prasad.
Appearing for the respondent number 1 in this case, Your Worship.
We represent the petitioner.
Also, there is respondent number 2 in this case, KMC.
Appearing for the respondent number 3, Model.
Fine.
Sorry, 2.
So who is respondent number 2?
Yes.
KMC.
KMC.
Okay. Please proceed.
Your Honor, this particular matter pertains to alleged medical negligence. I represent the doctor who is subjected to criminal prosecution under section 304A IPC. The backdrop of the case is as follows. A patient around 26 or 27 years old approached a particular doctor, that is Dr. Y, the petitioner in this case, with complaints of abdomen pain, vomiting, and having weakness. Accordingly, he was subjected to the warranted diagnostic examinations and advised admission. However, the younger brother felt that he can take rest at home, and accordingly he was taken. After 2 days, again he came back with much more suffering in terms of very abdomen pain, etc., etc. When other detailed tests also conducted, very clearly revealed that his kidney vitals, they are much above the normal range. And accordingly, he was admitted, whatever the treatment that was rendered, etc. And unfortunately, despite the warranted care and treatment, the patient passed away. The patient's brother subsequently filed a complaint before the concerned police jurisdiction, claiming serious offense that is committed by the doctors. He did refer to 1 or 2 paras in the discharge summary, and accordingly he said there is gross negligence on the part of the doctors, and accordingly they may be taken. From then onwards, it so happened, it is quite interesting in the history of medical law in this country. When the deceased was subjected to post-mortem, preliminary, final, post-mortem, very detailed manner report has come, indicating what are the reasons, etc. In addition to the post-mortem report and the cause for death, the forensic doctor also opined that there is gross medical negligence on the part of the physician, because had he conducted kidney functioning test during the first admission, the patient would not have died. And accordingly, on the basis of that report, cognizance, charge sheet, then cognizance, etc. happened. It so happened the patient's brother has also filed complaint before KMC. And KMC undertook whatever the proceedings, inquiry, etc. And KMC came to the conclusion that there is negligence on the part of the doctor. And accordingly, they have issued a written warning to the doctor. Your Honor, representing the petitioner doctor, we are before this court seeking quashing of the petition and the criminal proceedings under section 482 of CRPC.
What is your say, Mr. Counsel?
Your Ladyship, in respect of this very petition that has been preferred, at the very outset, I'd like to highlight that it is meritless and deserves to be dismissed for the reasons that I will substantiate now. Firstly, Your Ladyship, I'd like to highlight certain facts that would demonstrate the nature of negligence that has been committed by the treating doctor. And insofar as the facts that are concerned, I'd like to highlight the timeline of treatment that has been rendered and how the subsequent admission of the patient was uncalled for had the doctors had treated the patient properly in the very first admission. For instance, in para 4 of the facts, Your Ladyship, and I read, para 3. On 22nd August 2020, the patient became more hypotensic and hypoxic. On evaluation with USG and chest X-ray, he was found to have a large spontaneous pneumothorax on the right side, for which pigtail catheter was put and pneumothorax was relieved. The patient was treated with antibiotics according to the culture and sensitivity report. Despite so, the condition of the patient kept deteriorating, and the same was duly intimated to the family members. After suffering more complications, the patient expired on 28/8/2020 at 4:24 p.m. In fact, the second admission takes place on 21st of August, Your Ladyship. And at the very outset, I'd like to reiterate that the negligence can be discerned from the very medical records that are maintained by the treating doctors. My first contention, Your Ladyship, is the fact that the medical records have been poorly documented. There is no timeline of the series of treatments that have been rendered. There is no specific mention of the nature of medicines that have been administered. The doctor's progress notes are not legible. There have been overwritings in the medical records. And therefore, the very first contention that I'd like to highlight is the fact that the medical records have not been documented properly, which itself invites legal trouble for the treating doctors, Your Ladyship. Secondly, Your Ladyship,
how do you challenge the order passed by KMC? On what basis do you challenge?
Your Honor, there are two grounds. To begin with, Karnataka Medical Council is a body of experts created by a statute, having adjudicatory power, conducting inquiry, and come to rational conclusion. The first aspect of the order is that not only they conducted inquiry, but they have also upheld or endorsed or got influenced by the post-mortem report. Your Honor, first of all, whether a post-mortem report can deal with the cause of death or not, that requires to be addressed. A forensic doctor is not the doctor of concerned specialization who should come to such kind of conclusion. This is the sentence which the Honorable Supreme Court mentioned, paragraph 52 in Jacob Matthews case. Therefore, on one hand, Honorable KMC, while endorsing post-mortem report, came to the conclusion that the doctor is negligent, which to my mind, forensic doctor is not legally entitled, and endorsement KMC is legally blatantly erroneous. Secondly, the most important thing, Your Honor, every one of us, we know the civil negligence and criminal negligence needs to be differentiated from one word called gross. When, according to Honorable Supreme Court, the criminal prosecution can only be with regard to or in the light of gross negligence, I am now making a submission before you. How KMC's written warning can be reflective of gross negligence? If written warning itself is indicative of gross negligence, then what happens when there is a rustication? Say, for instance, in a given situation, the KMC rusticates a doctor for 3 months. What is that? Therefore, Your Honor, my submission is, insofar as KMC, there is an apparent and erroneous understanding. And they did not even look into whether a forensic doctor. In fact, KMC is the right body to come to a conclusion and a challenge whether a forensic doctor can mention about the deficiency or negligence on the part of the doctor. Therefore, because of these two submissions, I challenge the KMC order.
To you, there is no independent expert opinion produced in this case. There is no other independent expert evidence which is produced on record by the police.
No, in fact, the investigative police officer initiated the charge sheet, etc., leading to cognizance by the magistrate only on the basis of post-mortem report and KMC report.
Your Ladyship, I just have a couple of submissions. Your Ladyship, I have a couple of submissions insofar as the KMC order is concerned. I'd like to highlight one crucial aspect in this case. My learned opponent is challenging the very credibility of the KMC order. But to much surprise, there is no whisper challenging the very credibility of the KMC order before this honorable court. For instance, the prayer claimed by the petitioner is to quash all the criminal proceedings. But in my respectful submission, there has been no contention taken by the petitioner challenging the very credibility of the KMC order. And in the absence of any such challenge, the need for a quashing of a criminal proceeding simply does not arise. More so when it is at a preliminary stage, Your Ladyship. In fact, all the contentions that have been highlighted by my learned opponent require trial, Your Ladyship. And therefore, these questions cannot be decided at a very preliminary stage and by this honorable court. And all these issues of whether the post-mortem report can be construed as an expert opinion are matters of merit that have to be decided by the criminal court, Your Ladyship. And therefore, to quash the instant proceedings would be premature, Your Ladyship. And therefore, I respectfully submit that there is no apparent deviation from the settled legal position highlighted by the Honorable Supreme Court in Jacob Matthew's case. It is not the case of the petitioner that there is no expert opinion taken. It is not the case of the petitioner that the KMC order is mere a prima facie opinion. Absolutely not. The KMC proceedings, and as my learned opponent, my co-counsel will also demonstrate, were a detailed set of proceedings where both parties were heard at length. Evidence was led, cross-examination took place. And after detailed deliberations was this warning issued. And therefore, not only is there no challenge to the KMC order, even if it is, there is no basis on which it can be challenged, Your Ladyship. And therefore, to even quash the proceedings at this very level would be premature, Your Ladyship. And therefore, I humbly pray that the instant proceedings may be dismissed.
Your Honor, I may be given an opportunity to respond to what my learned opponent is saying, particularly after the Karnataka Medical Council's submission. I want to make.
My Lord, we conducted detailed inquiry, my Lord. And equal opportunity was given to both the parties for evidence, medical records, and arguments. After that, the KMC has passed the proper investigation and analysis basic, my lord. That's all.
Your Honor, to begin with, my learned opponents claim that I'm challenging the credibility of the KMC's order. In my opinion, that's not correct. I'm not challenging the credibility of the KMC's order. I'm challenging the legality of the KMC's order. Credibility doesn't hold water. Legality. Your Honor, legality, it is for the simple reason KMC itself is a body of expert doctors. Their own independent decision would have given the clue as to whether the person is negligent or not. There is the need for endorsement of forensic doctors, so-called expert opinion as to whether doctor is negligent or not. One more submission, Your Honor. My learned counsel representing KMC, he said that all the principles, procedures, like principles of natural justice complied. I never said that you have not followed the principles of natural justice. You have followed. My only submission is, if you issue a written warning, can that justify gross negligence? Who is going to decide in this country? Since so many years, this particular issue is being debated. Therefore, I'm saying, even though the KMC may be justified in giving a written warning, I'm saying that particular written warning does not justify criminal prosecution. Therefore, investigative officer cannot squarely depend upon KMC's order for the purpose of pursuing prosecution. Your Lordship, that is the reason why, in tune with what Honorable Supreme Court said in Jacob Matthews' case, literally, this particular case deserves to be quashed for the simple reason there is nothing to indicate there is gross negligence reflecting the professional conduct on the part of the doctor. One more point, my learned opponent was saying that certain documents and prayer, etc. In my opinion, certain rectifiable errors, I don't think demand continuance of prosecution. If at all there is a need for filing, I undertake to file that prayer. But that does not mean the High Court should not look into the issue whether this petition deserves to be allowed or not. Therefore, I pray for allowing of this petition, and accordingly, the criminal prosecution proceedings may be quashed.
Considering the materials on record, this court is of the opinion that there is no gross medical negligence, and therefore, even assuming that the doctor's act can be labeled or can be attracted under the civil liability of negligence, but the ingredients of gross negligence as mandated in the Jacobs Matthews case are not satisfied. Therefore, the instant petition may be allowed.
Much obliged.
Obliged.
Obliged. Raise.
Silence.
Thank you, friends.